The Honorable Angela Russell, you know, that presiding over the
Good morning and welcome to our May 12th, 2026 case call, day one. Sitting with me today are my esteemed colleagues, Judge Annika Letica and Judge Kathleen Feeney. And I should note that if you have an opportunity when you're in Grand Rapids today, Judge Feeney and her longtime associate, Judge Yates, recently had their portraits hung at the Kent County Courthouse due to their long service in that court. And so I encourage you to go over there and take a look. I wish I could have gone to that ceremony, but unfortunately, I had something that I had to attend to. But I wanted to mention it here today because it's a true accomplishment. Congratulations, Judge Feeney.
Thank you.
We're going to get started in a second. Before we do that, I want to mention that some of the cases today involve minor children. So rather than refer to the minor children by their names, please just refer to their initials. And with that, we will call our first case, which is number one on the docket, case number 376529, People v. Copeland.
Good morning. May it please the court. Tom Oatman from the Muskegon County Public Defender's Office on behalf of Kymel Copeland. I was expected to be joined in the courtroom today by Attorney Kendra Robinson from our office, but there may be some construction holding her up. I know you've read the briefs. I'm here unopposed, so I will keep this short. I do have one small correction I want to make to my brief. And I went back and forth on whether I should move to expand the record to include the text messages that are mentioned at the motion hearing. It's a bit unclear. There's some comment that the messages were sent.
It's hard to rule on things that information that you don't have that the trial court had.
Exactly.
Just put it that way.
And I don't think the trial court even had the messages in front of him at the time of the hearing, although he did preside over the earlier
trial.
Right, exactly.
But why would you want him to have to recall that from the earlier?
No,
hearing?
exactly.
That makes no sense.
So it seems that if you were moving to admit the messages, you would want to present them to the court.
Right.
So you would see them. The prosecution's brief, fortunately, on page 11 does have the dates correct. The second message was sent after the other act shooting, not before. So if the court was confused about why would that message about the gun didn't work, it kept jamming, why would that relate to the second shooting if it was sent before that shooting? It's because it wasn't sent before that shooting, it was sent after. I don't know how much that will play into the court's decision, but I just wanted to make that correction. As to point issue one, I don't see any disagreement from the prosecutor that this was argued and decided under the improper theory of common plan or scheme. It needs to come through modus operandi if it comes in at all. And so I think the appropriate thing to do would be to reverse, send it back. If the prosecutor wants to bring it in under modus operandi, they can file a new notice of intent and it can be argued and decided.
But they did file under intent or identity. I'm sorry.
Identity.
Yeah.
Right, but identity can be shown in many ways. Modus operandi is only one of them, but common plan or scheme is not appropriate.
Okay, so and that's because you're conceding all the elements of the charge offense occurred. They just weren't committed by your client. Is that correct?
That will be the argument that's made at trial. Yes.
All right, so if Evans didn't identify your client, would this evidence be relevant to establishing identity when the perpetrator wasn't identified?
Would this evidence be relevant? The only way it would be relevant would be through modus operandi. And I don't think it satisfies that standard. They're similar, but they're not distinctive. There's nothing unusual about the commission of the two shootings that marks it as the work of the same individual. These are just two shootings where somebody spotted their target, drove to a secluded spot, moved up through stealth, shot, returned to their vehicle and drove away. That is a fairly generic way to commit this kind of.
What about the jammed gun?
The jammed gun, I don't see how that shows similarity when the prosecution is conceding that it's not the same weapon. If it were the same gun that kept jamming, I could see how that would prove identity because the same weapon was used in each offense.
It isn't the theory that it was a ghost gun, so these are guns that can just be produced. So the same assailant is using ghost guns in both?
Except in the second one, it was a manufactured weapon. It was an actual Glock weapon.
But I thought, like, was there let's see, a certain firing pin aperture mark on the spent shell casings at the Franklin murder? That was a question I had.
Yes.
Because
So
it's that firing pin aperture mark, which shows it's from a manufactured gun
at the,
at the Franklin murder.
which is the charged offense. Yes. All along, the prosecution has been arguing that this was a 3D printed gun that was used in the charged offense. That's a point that has not come up in our discussion, so I'm not sure how to answer.
So if we were to send this back
Yes.
on issue 2, should we just send it back on issue 1 as well? To reevaluate?
I think that is the most economical way to handle this, that it's an argument that should be considered by the trial court in the first instance,
Okay,
not by this court on review.
we're not at least I don't believe we're a fact-finding court. so
Exactly. This is a court of review, not first view.
It's correct.
As everyone says.
Okay.
Okay, if there are no other questions, I'd be happy to sit down.
Any other questions? No, thank you.
All right.
Have a good day. That
you.
case
You
is
as well.
submitted. Calling case number 2 on the docket, number 367027, People v. Glasper.
Good morning, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of Mr. Glasper. This is well briefed, in my opinion, with several issues where
It's extensively briefed.
Extensively briefed. with several errors that the state made in sticking to their version of what they believed had happened, and also the failures of trial counsel to object. I want to focus on 2 issues unless the court has questions about the other 4 issues. The first one I'd like to discuss is the proffer, and the second one is the burden shifting. The proffer here, Your Honors have the proffer agreement, and the terms of it were clear, that if he proffered, told the truth, then they would give him a sentence of 20 years. Mr. Glasper fulfilled his end of the bargain. And then the prosecutor, when he fully confessed, waived his Fifth Amendment rights, fully confessed to what he did, that he was the shooter, the prosecutor said, whoa, we're not going to make a deal with the shooter. I think that a relevant decision of the Michigan Supreme Court for this court to consider is that of Reagan, where seemingly the prosecutor there said, we'll cut you a deal if you pass a poly.
Right.
And then he passed the poly and they said, oh, well, we're not really sure if the polygraph is reliable. Well, the Michigan Supreme Court said, maybe you should have thought of that before you entered the deal. And that's the same here. Maybe the prosecutor should have been clear about what he had to say to get the 20 years. It doesn't make a whole lot of sense what they expected of Mr. Glasper besides to tell the truth, which he did, and is consistent with the eyewitness testimony of Ms. Nelson, who said that the man in black was the one tussling over the gun. That was Mr. Glasper. Mr. Glasper was in black. Mr. Shaw, the co-defendant, was in red off to the side. That's consistent with the only eyewitness to the shooting. So what should happen here is that this court should remand and order specific performance of the deal that the prosecutor entered into with Mr. Glasper. I also want to talk briefly about the shifting of the burden of proof here. It's interesting because in the trial court opinion, the trial court in denying this motion for a new trial cited to Bass and said examples of ways a prosecutor may improperly shift include stating that an acquittal would require a finding that all the government's witnesses were lying, informing the jurors of precisely what they must find to convict or to acquit, or excluding other ways to reach a verdict. That's a correct statement of the law, but then the trial court judge seemingly ignored the prosecutor's own words. And those are listed extensively in the brief, but there's a couple that I want to point out. Volume 4 of the trial, page 28. The reality is, this is the prosecutor, the reality is in order for you to excuse Mr. Glasper's conduct, in order to say, yes, you killed a man, but we're going to excuse it, is you have to believe his version of events. Later on, pages 28 to 29, the prosecutor says, so you would have to basically take all of my evidence, all of this, and throw it in the garbage and say, forget it. And in fact, on page 38 in the prosecutor's closing argument, trial volume 4, he tells the jury incorrectly what they have to do to acquit Mr. Glasper. In order for you to acquit Mr. Glasper of murder, you have to decide that his version of events are true. That's after multiple statements where the prosecutor was saying that Mr. Glasper did not corroborate his version of events. Then on page 39, you literally would have to take my evidence, throw it in the garbage to render any verdict other than guilty. That is classic burden shifting under Bass, which the trial court acknowledged in its rule statement in its opinion, but then proceeded to ignore the prosecutor's own words. And that is improper. And on that basis alone, Mr. Glasper should be given a new trial. This court, in an unpublished opinion granted in Wade, when addressed from 2016, when addressing the harm that comes from burden shifting, this court said that the defendant has the burden of proof, even if only as to self-offense, the error is not cured unless the court specifically addresses the improper remarks and directs the jury to disregard them. So what should have happened here, the general instructions did not cure the harm that came from the burden shifting. What should have happened, and trial counsel failed in doing and failing to do this, is for the judge to say, these specific comments of the prosecutor must be disregarded. It is not Mr. Glasper's burden.
But doesn't the trial court in its instructions to the jury say the arguments of counsel are not evidence? And I'm going to tell you the burden that you have to apply. And then we give them the jury instructions to take back with them. So why doesn't that take care of it?
I would just point this court to its own opinion in Wade. Yes, it's unpublished, but that talks about the harm that comes from burden shifting needs to be specifically addressed by the harmful comments, that the general instructions that trial judges around this state give at the end of every trial about the burden and the comments of the prosecutor and defense counsel in closing arguments, that's not enough.
But you said this in 2016. So 10 years have gone by and no other court of the Court of Appeals has decided that Wade needed to be published. That's kind of remarkable to me because I think there's more cases that say, no, the court's instructions to the jury that the arguments of counsel are not evidence, and I will tell you what you have to apply for the burden is the appropriate way to go. So I'm not sure I can go with you on that.
I think this court should take the opportunity to do just that and publish an opinion that says these general instructions aren't enough when we're talking about a fundamental constitutional right, such as shifting the burden of proof, especially when you have the prosecutor doing it in multiple ways, multiple times. His whole closing argument was infected with this burden shifting, talking about Mr. Glasper not presenting any evidence.
Let's talk about that for a second. Let me
Okay.
ask you a question. Other than your client's testimony, is there any evidence in the record at all that shows that Shaw was not involved in the incident?
Well, I think that gets to the multiple other errors, to be honest.
It's a very specific question.
Okay.
Tell me what in the record shows us that Shaw was not involved other than your client's testimony?
The testimony of Ms. Nelson, the eyewitness. So she testified that the person who was wrestling, fighting with the decedent was dressed in all black. You combine her testimony about being dressed in all black with the multiple surveillance videos that were introduced where Mr. Glasper was in all black.
I thought Mr. Shaw was as well. And the only thing that I could really tell between them was that Mr. Glasper wore these amazingly gold tennis shoes, like they were iridescent gold. And Mr. Shaw wore red tennis shoes.
Mr. Shaw had red tennis shoes and a red sweatshirt.
Then doesn't the video show Mr. Shaw changed clothing at some point in
At
time?
some point, we
He
don't
got
know
rid of
whether
the
it was
red
after the
sweatshirt.
shooter, after the shooting.
Right, but at some point he's all in black, right?
It was in the videos, I believe, as I recall. They both
In the,
were.
let me check real quick, Your Honors, but my understanding of the videos is that he had switched shirts at some point and nobody was clear when that happened because it is
Right.
undisputed.
Okay, sure. But what color was his shirt that he switched into? It was black, right? He wasn't all in black.
I think so, but that could have been after the shooting as well. The evidence we have, we know Mr. Glasper was in all black. And we know that at some point, Mr. Shaw had on a red shirt. We also know that Mr. Glasper and Mr. Shaw went up to Mr. Shaw's hotel room after the shooting. It could have been at that point. But it is not, there is no evidence that that's the evidence I would point to that Mr. Shaw was not the shooter. He was involved, he was there. So I don't want to mislead this court in saying that he wasn't part of anything. He was present during the shooting. But
Yeah,
there's also,
that's a problem too, because your client testified at the trial that he wasn't even there.
I believe he testified that he had no gun, that he was standing off to the side.
No, in the proffer interview, he said he came there as the incident was happening, but at trial, he said that Shaw wasn't even there.
That's not how I remember the record, Your Honor, but I trust you that that's the proper interpretation. My understanding all along has been that Mr. Glasper has said he didn't have a gun, not that he wasn't there ever. And I think it's
And I'll certainly-
undisputed that he was there.
I'll certainly go back and look.
It's certainly undisputed that Mr. Shaw was there because we have an eyewitness placing two men and her significant other.
Well, and the video shows the two guys. I mean, there's so many cameras in the Clarion Hotel. It's like, wow, I'm watching like 30 of them. That's
Right.
why I'm almost positive. I'm going to go back and look at it right now because
Yeah, there's no footage of your client where Shaw isn't close by.
Correct. Right. And that's why it wouldn't make sense to me that he would actually testify that he wasn't part of it ever or that he wasn't there. Maybe he came in at the end. I think that what we have, and this does get to the narration issue too, is that it was improper for the detectives to be up there saying, this is what happened. And that's evidenced by our discussion here this morning, is there are different interpretations. It was improper for two detectives to say, this is what is happening in these videos. Juries can figure that out for themselves or debate among themselves, just as we are doing here today. But there's also no evidence, the prosecutor introduced no evidence that Mr. Shaw was the shooter. They had hearsay statements from the jail that gets to the innuendo issue, which was wholly improper for the prosecutor to suggest that Mr. Glasper was changing his statements based on inadmissible evidence. You have this letter from Shaw where the prosecutor has mischaracterized that letter as saying that Mr. Shaw took responsibility for this, when really he was just telling Mr. Glasper, hey, I'll take this case for you.
they're both dressed in black and really dark gray. According to the video I'm looking at right now.
I was trying to find, I believe there's a picture in my brief where Mr. Shaw is in red.
Oh, I see it now. It's like got a red on the shoulders.
Yes.
Now seen from behind. I stand corrected. Thank you.
So all these issues interplay together, but it certainly wasn't, going back to the proffer, it certainly wasn't the prosecutor's job to say that Mr. Glasper was lying and therefore breached the proffer agreement whose terms were laid out clearly. Unless this court has further questions, you could remand to the trial court for an evidentiary issue on some of these. I raised most of them as ineffective assistance of counsel for failure to object, or to remand to see if the prosecutor had a good faith basis to introduce these out of court statements or make this innuendo. This court, for further factual finding, can send this back to the trial court. And maybe that's the proper remedy here today with so many questions outstanding.
Can you talk a little bit about issue 5? The reading of the letter and that being ineffective assistance of counsel.
Yes. So that's interesting. Issue 5 is interesting because the trial court actually didn't opine on issue 5. And I read that opinion several times to make sure I wasn't missing anything. But so they read this letter out from Mr. Shaw to Mr. Glasper. There were no objections based on hearsay. And I think that it's telling too with issue 5 because the prosecutor in their brief said, well, they just used this letter for impeachment. It's not to prove the truth of the contents. But the whole rest of their brief, they're using this letter to show that Mr. Shaw was the shooter. So there's not a doubt in my mind that the prosecutor was introducing this letter at trial to show not only that Mr. Glasper was lying and to impeach him, but to show who the true shooter was.
So let's say that we take them at their stated purpose, that it was used for impeachment. Is it proper to use it for impeachment? Because you can use anything for impeachment, right?
I think you could use it for impeachment, but they also misrepresented the contents of the letter which is another problem that the prosecutor did here, is they were saying that, oh, Mr. Shaw admitted to being the shooter. That is not, and your honors have the letter. That is not what the letter says.
Wait, how can you impeach somebody with a letter that they never saw, that they didn't write? Impeach means you're contradicting something that they said or something they argued. I don't understand how that's even possible.
Well, I agree with you, Your Honor, that it shouldn't be used to impeach, especially because my recollection is that Mr. Glasper rejected even holding these letters from Mr. Shaw. People tried to get him messages, at least one message, in the jail, and he said no. So he didn't know any of this.
I mean, because we allowed something like that, then in any case, you could simply have a witness draft up a letter and get it in against the defendant and say, well, this is impeachment, even though you've never seen this thing before.
Yes, and the prosecutor said at trial, that's a letter from Mr. Shaw to you, acknowledging he's the shooter and acknowledging this is a robbery. He didn't want to tell the police the truth, but he did want to tell them you were the shooter to get out of it, get himself out of trouble.
Seems like the problem, though, is pretty obvious here, which is that evidence came in through another witness. Jackson said that Shaw apologized to the defendant for shooting him.
That was I'm just trying to think through whether it's the same evidence or not.
It's literally the same.
Well,
it's Shaw admitting that he shot, that he was the shooter.
He said, I think that in the heat of the moment, remember that Mr. Jackson, I think his name was, at this house on Broadway, was trying to fix up Mr. Glasper's leg, who had been shot. And he remembers hearing something like, sorry, you got shot, or sorry. I don't believe Mr. Jackson's testimony was that explicit. And I don't want to misrepresent things. And I'm trying to find the actual quote here of what he allegedly said. But it was a chaotic moment. And I think a fair reading of that too is that Mr. Shaw was like, you got shot. I'm sorry about that. Like not expressing empathy, more expressing empathy than apologizing for shooting his friend in the leg. That isn't, in my mind, incredibly persuasive evidence that Mr. Shaw was the shooter. And quite frankly, I don't know that it matters when you're looking at all these other errors. It doesn't matter who was the actual shooter when we're looking at the harm to Mr. Glasper from some of these errors, especially the burden of the proof shifting. It doesn't matter whether Mr. Glasper was the shooter or Mr. Shaw was the shooter.
Well, Certainly matters as far as your first argument goes, because if if Shaw's the shooter, then he lied, which means the proffer is off the table, rightfully so, right?
And we might never know. And I think that
But the point is, it matters.
it matters to a certain extent, because again, this court really needs to look at the language of the proffer to determine whether it was breached. And that, again, I don't think the Kent County prosecutor had a very clear proffer here, what they expected of Mr. Glasper. They expected him to implicate Mr. Shaw. That is what they expected. They did not get that and therefore withdrew their proffer, even though that was nowhere in the terms of the agreement. And that, again, I would point this court back to Reagan. They made a bad deal. And they should hold up their end of the bargain. If there are no other questions, I thank the court for their time this morning.
Thank you. Let me just say that that you and your partner did an excellent job on that brief.
Thank you, Your Honor. Appreciate that.
Okay, that case is submitted. Calling number 3 on the docket, 371-092, People v. Singleton.
Morning.
Morning.
So Ronald Ambrose appearing on behalf of Mr. Singleton. This is a one issue case. The issue in the case is really not whether Mr. Singleton had a valid Wayne County custody order. It's whether or not he thought he had a valid Wayne County custody order. And during the trial, he was not permitted to argue that his understanding of the order that he had was a valid order.
But it went to excess, right? Because if you say, okay, here's your parenting time, you get every other week or every other weekend, and he holds them for 3 months, that provides nothing. It's a sham argument, because had he thought he had a valid order from Wayne County, he would have said, oh, here you go. I give them back. This is your weekend now, and then I get them back next weekend, or here's your week, my week back. You don't just hold them indefinitely and then say, but I had a valid order, because the order didn't say he got that time, correct?
Well, the order has a provision in there every other week, and then it reverts to, I think it's paragraph 2 of the actual order, that parenting time will be exercised on a week-on, week-off basis until an arrangement can be made that is more acceptable to both parties. And
Sure. So he didn't do week on, week off. He kept them for a long time.
you can make the argument that, or that he was being denied parenting time was his testimony. And
So wait. So you're saying that his belief that he was denied parenting time before the order ever existed gave him the right to ignore the court's order that said week on, week off? I would have had problems with that during a couple of decades being on the family division,
yeah, I understand.
because when we said week on, week off, we meant it.
Yeah. And like I said, though, it's what was his understanding of what he had.
But you read it. The words are very clear. Week on, week off. That means he got the kids for a week, and then she gets the kids for a week, not months. Doesn't say month on, month off.
Correct. And it also said, that last paragraph.
But they
or
didn't
the last-
agree. There was no meeting of the minds on the fact that he's just going to keep them for 3 months plus. So that part doesn't do you much good.
He allowed mother during this period of time that he had the children, they had met in person. And that was his testimony.
But
too,
it's
as
still,
well as-
it still wasn't consistent with the order. I mean, so that Wayne County order, whether it existed or didn't exist, is completely irrelevant in my mind because he didn't follow it. He kept them, even though he let her see them, he never let them go back to mom's custody.
Okay, but he's not allowed to testify to the jury that I would say that he should be allowed to testify to the jury that my understanding of this Wayne County order was that I could have the children. That's all I'm not saying that that the Wayne County order was valid because it's clear that it wasn't. I'm saying that he should have been allowed to testify that he thought he did have a valid order because it is a specific intent crime. It's just a matter of, is he allowed to present a defense to the allegation? Even the complaint in the case, the complaint itself, there was a delay in charging him. And the complaint says, it's not, there was conflicting paperwork at the time in regards to if Singleton had rights to the children. So the police go out there a number of occasions or I guess were contacted on a number of occasions and don't act on it because they just figured it was a civil matter.
And which they do all the time.
Yeah.
And again, but the police aren't going to sit there and say, well, we're going to read these two orders and then decide. Again, his desire to keep the kids to the exclusion of the mother. That doesn't seem to save him, right? His belief that he could exclude the mother from these children's lives, that doesn't save him.
I'm not saying that. All I'm saying is that he should have been able to testify. He was prevented from testifying that what his belief was in a specific intent crime.
Can you remind me, what was the evidence put in with regard to proof that he was served with the Kent County Circuit Court order?
Berrien County?
Or Berrien County, sorry.
That his testimony was that he wasn't served.
No, I know. I'm saying what was put into evidence showing that he actually was served? Was it publication in the newspaper or certified mail?
I think there was like a proof of service, but
Okay. Fair enough.
But I mean that the issue. I understand where you're coming from, Your Honor. If this was in family court, but we're in a criminal proceeding, and to prevent a defendant from testifying as to what his belief is on whether or not he had a valid order, yeah, I think he should have been allowed to at least make that statement to the jury. It was a pretrial ruling by the court, and when my client got up there and testified, he fully admitted he wasn't sure what he could and couldn't say. So that's all I have.
Questions? No? Okay, no further questions.
All right,
Thank you.
Thank you, Mr.
That case is submitted. Thank you, counsel. So we're going to call case number 4 on the docket. That's case number 369-337, People v. Handrich or Handrick.
Good morning, Giannis. My name is Cecilia Carandongo. I represent Mr. Handrick on appeal.
Please proceed.
Sorry, there's a terrible lag again. This is a 3 issue appeal. I think so. The first issue revolved around the jury instructions. There was Mr. Handrick was charged with homicide. The jury was instructed on both first and second degree murder, and the court declined to instruct on the manslaughter. My argument is that was error. Because there was evidence supporting that this could have been manslaughter, that there was some provocation, both not only with words, but also action that I laid out in the brief, which revolved around some type of physical assault on Mr. Handrick. and also words in regards to his past. I believe that there was evidence that he was provoked and that would have reduced the mens rea, and that there was evidence supporting, therefore, that there should have been a manslaughter instruction. I believe the case law supported that as well. So that was the first issue. I believe also that there was prejudice in that Mr. Hendrick clearly, so he was convicted of the murder, but there was, again, a reasonable juror could have found him guilty of the manslaughter had they been properly instructed on it. The second issue was an argument that there was insufficient evidence to convict Mr. Hendrick of first-degree murder. As the court is aware, insufficient evidence to support a conviction violates a defendant's right to due process. And in this particular case, it revolved around the lack of sufficient evidence around the premeditation and deliberation. There was, I don't want to say an abundance, but there was a lot of evidence that Mr. Hendrick and the complaining witness had engaged in consensual sex, which included suffocation, and that Mr. Hendrick did make some statements that indicated that he had, in the past had similar sexual interactions, but that he'd already always stopped when the partner had requested him to do so, that there was no request that he stop, that he possibly had held on to her for too long, which supports an argument that it was an accidental suffocation and not a deliberate one.
But I thought that she died from the closed head injuries.
Well, Your Honor, there was some evidence too that some of those wounds could have happened, while she was being dragged or by hitting her head against a tree stump, which also would indicate no deliberation. I think, at least in my reading of it, and the court can of course disagree with me, is that the suffocation part is what is basically what was argued in regards to the premeditation and deliberation.
But I thought in the police interview, he said, as you mentioned, that he would have stopped hitting her, choking her if she said to stop. But in the written statement, he admitted that although the victim tried to push him away and get him to stop, he choked her harder because it was better for him.
Well, Mr. Hendrick made a lot of different statements, which is why I also think that, it's problematic, to argue the deliberation and premeditation, because I think there was a range of statements made by him. Some supported accident, some didn't. But I do think that there was substantial amount of evidence that supported that the death could have been accidental. And I also think, in hindsight, the situation with the argument about provocation could also support the argument that there was no premeditation and deliberation, because one would need to be not hot-blooded in making that determination, to commit first-degree murder.
But was it the are you saying the provocation was the request that he claims that she made to probably excite him, I'll call it, and he decided that was a wrong thing, and then
there was some evidence of of her doing some type of, I don't know, anal touching.
But
that was my argument about the physical.
But you're saying that's the provocation? She provoked him by doing that when she asked him if she could do it beforehand?
That was the provocation. That's correct.
But he didn't say no. Right? He let it go forward.
That's correct, Your Honor.
Okay.
The last argument, which was the third argument, was the admission of evidence, which revolved around the court admitting evidence that Mr. Hendrick was watching sexual materials or pornographic videos in his hotel room sometime after the complaining witness had passed. I argued in there clearly it was designed to portray him as a sexual predator in a case where he was not charged with a sexual assault. it was both irrelevant pursuant to MRE 401 because it didn't make any fact more probable than another. And it was also definitely more prejudicial than probative, contrary to what's required by MRE 403, because the only purpose was to make him look like a sexual predator in a case where that was really not an issue. There was other evidence in there, of course, already that Mr. Handrick and the complaining witness had engaged in rough sex, but that was consensual. He was not charged with a CSC of any kind. This type of evidence is always highly prejudicial, and it should not have been omitted in this case. I do believe that it could have led to a miscarriage of justice and his conviction for the CSC one. I apologize for the murder one in a case where there was a lot of time spent on talking about Mr. Handrick and the complaining witness sexual interactions, but not a case where he was charged with CSC. So I do believe that would have made a difference in the case had it not been admitted, and that he should be granted a new trial based on that.
Are you saying that he should have been charged with CSC one?
No, I'm not saying that. Sorry, that was me misspeaking. He should not have been charged. I apologize. It was a case where he was not. I'm sure if the evidence supported it, they would have charged Mr. Hendrick with a CSC one. And in that case, and I'm not trying to say, but it would maybe have been a little more relevant than in the case that we had. I think there was a lot of effort made to make him look like he was basically a sexual predator, which held no bearing on the charges he faced, is what I'm trying to say. So that's why my argument is that it was the prejudice greatly outweighed the probative value. There was no reason other than making him look bad for admitting that evidence. And unless the panel has any questions, I'd rest on my brief.
Questions? No questions. Thank you so much.
Thank you.
How about that last point? How in the world was that evidence admissible in this case?
Sure. If I can place my appearance on the record. Good morning.
Do that first.
May it please the court, Nick Johnson, Assistant Attorney General on behalf of the people. Judge Wallace, as to your question on the last point, we briefed in our briefing that it was pertinent to his overall state of mind. Really, there's no question here.
Fact?
Pardon me?
After the fact?
Well, there's no question this was a sex crime, and the question before the jury was really whether this was premeditated and deliberate. And this court's case law in Walker, cited in the People's Brief 2019, says that part of the analysis looks to what happens after the crime. And
okay, so what's the state of mind then?
So throughout between the murder and his cover up within a few days, he's talking with people, he's having communications with people on the same exact cell phone. And that within that, he's viewing pornography. And again, there's really no question that this is a sex crime, and what his motivations were central to the issue at trial. I do want to note as well that it was really very, in terms of its extensiveness at trial, it was at the very end of trial. There was an objection made, and at that point, there was no other reference to his viewing pornography at any other point. The prosecution didn't mention it in her closing. And also, defendant's own written statement had said that he went to bed and viewed Pornhub. So this was really cumulative. This notion that he was viewing pornography was cumulative of his own written statement saying that he had viewed it. So I think even if there is error under the preserved unconstitutional standard, any error was harmless, specifically when you look at its cumulative nature. In addition to, it's often said that evidence is overwhelming, and I think this is particularly a case where the evidence was extremely overwhelming against the defendant.
You'd agree with us that that's a much stronger argument than arguing that it's admissible.
I do. I think, yeah, absolutely. I mean, we have an abuse of discretion standard, but ultimately, if there was error, it was harmless, and that's people's position here. So, Just briefly, if I can mention the other, just a couple of rebuttal points as to the other two issues. The case law, with respect to the voluntary manslaughter instruction, the case law, Pouncey cited in the People's Brief says words are not enough. And really, there's no indication what was said to the defendant in terms of the words. As to the act, Judge Feeney, as you mentioned too, there's conflicting evidence as to whether it happened at all. He didn't mention it to police. But if it did happen, the evidence indicates that he knew it was coming and that he had the ability to stop it if he didn't like it. And all indications are he either welcomed it or knew it was coming. And not only that, but obviously there was substantial cooling off period such that it didn't constitute adequate provocation. And Judge Feeney, just real quick, you also asked for the cause of death. The record, as I read it, indicates it was both blunt force trauma and strangulation is how I understood it. So I don't know that there was a determination as to which specifically, but and then just briefly, Your Honors, just the sufficiency to the standard. This court's well aware that the evidence most light in favor of the prosecution, draw reasonable inferences, and given the evidence here, I think there was more than sufficient evidence for premeditation and deliberation. So if the court has any other questions, I'd be happy to try to answer.
The death certificate was admitted as an exhibit, right? If you remember, if you don't remember.
I don't. I apologize. No, I don't. I know there were hundreds of exhibits admitted. So, yeah, I would defer to that though if it was.
Okay, thank you.
His phone records show that he was there at the scene.
I'm sorry.
His phone records show that he was there at the scene.
Yes, there was cell site. I believe there was cell site data in addition to obviously DNA evidence of him with a vaginal swab, and I believe the victim's blood was on his underwear as well. So there was substantial evidence.
Okay, no questions.
Thank you, Your Honor.
Thank you. Counsel?
Nothing else, Giannis. Thank you.
Thank you. That case is submitted. Thank you, counsel. We're going to call the next case in a second. Okay. Calling case number 5 on the docket. Number 366350, People v. Childers.
All right. Good morning, Your Honors. Jason Eggert from the State Appellate Defender Office on behalf of Heather Childers. Understanding the court has had a lot of time to look at these pleadings, I'd like to focus my arguments on issue 2, and I'm happy to accept questions about any of the other issues before the court. As the court's aware, the issue in issue 2 relates to a claim of ineffective assistance of counsel due to trial counsel's failure to present photographic evidence, which would have supported her theory of the case. And I think, to focus in on kind of the arguments of both of the prosecutor on appeal and then the justifications of counsel, I think it's important to look at what the context of what the prosecutor's theory and what the defense theory was here. And the prosecutor had a very clear theory that this was a premeditated assault, that Ms. Childers brought a knife to this home for solely one purpose, which was to attack Ms. Johnson. And now the other key aspect of the prosecutor's theory was that there was an immediate rush to come in and do this. You pull in the driveway and immediately rush up in a fit of anger to assault her. The defense presented a much different theory, and that was that he was there Ms. Childers went there to help her father fill out VA paperwork, and that the knife that was brought to the scene, which was a paring knife, was brought to cut ring bologna and cheese, but notably missing from trial counsel's evidence at trial was any evidence that bologna and cheese was brought or that there was some other purpose for this paring knife to even have been brought at all.
Oh, she could have left it on the table then. I don't think the fact that there was bologna and cheese on a table outside in the yard then justifies bringing it up to the house. She's told she can't come in, leave, and then she goes after her father and his caregiver.
So I think that that's obviously the prosecutor's version of events here. I think the difference here is that the defense is attempting to present that there was no premeditated attempt to assault. This was brought for a specific purpose, and the prosecutor, rightfully so, in closing argument says there's no evidence to support what the defense is saying here. They didn't present any evidence. And this photograph was readily available. It was in the pack of the 10 photos that were admitted through Trooper Awad. And it was something that spoke directly to her intent. It would have corroborated what Ms. Childers was attempting to argue to the court through her counsel. And when you present a theory to court in opening statements, of course, the jury is going to expect, well, at some point, I'm going to see some evidence. And this is very clear demonstrative evidence that would have supported Ms. Childers' theory regarding intent, that this wasn't a bull rush to the door with a knife for no other purpose than to come in there and assault Ms. Johnson.
I mean, all it actually would have given the jury is evidence that after all of this occurred, whatever occurred, police took a photograph of your client and that these items were on the table. These items specifically just being the cheese and the bologna.
Sure, that's what the photo shows, is there's an after the fact photo, correct? But what counsel would be able to argue is the fair inference of that evidence is that that didn't materialize out of nowhere, and that she could make a fair argument that this was something that was brought beforehand, and it corroborates the theory that she has, that Ms. Childers didn't go there with ill intent, and that, as she argued, things just happened to get out of hand.
But likewise, the prosecutor could have argued that she brought it over to that table after all this occurred, because there was a period of time that passed after the incident to the time when the police arrived,
Sure.
right?
Sure, that could, the prosecutor, of course, if defense presents evidence, which they did not hear, the prosecutor would have the opportunity to try to poke holes in that. The failure here is the fundamental duty of counsel to present evidence to support the theory that they put forward to the jury. And as we point out in our briefing, the reasons given by counsel simply make no sense, that there was some initial aggressor theory that she had that was not articulated in any form to the jury, and there was no self-defense claim. That the photo, somehow would undermine this theory that she was snuck up upon at the table. But as this court's aware, this was a photo taken after the fact. And when you look at the physical layout of where it was at, it, of course, would have been able to approach the table by any side. So in no way contradicted what counsel seemed to have a problem with it. I think it just merely, with all due respect to trial counsel, represents a post hoc rationalization of, oops, I made a mistake and here's a reason I came up with. And I think,
But wasn't the incident, the scuffle on the porch at the front door? So it wasn't at the picnic table.
so the scuffle, according to the testimony, kind of went all around, right? There was a confrontation on the porch that included the area around the picnic table. It involved according to the complaining witnesses, a grill that was also on the porch.
But the
And there
table,
was also an interaction at the door where there's pulling on the door handle and things like that. But this was an event that I think the record is not so clear cut that it was only at the door. It shows that there was a scuffle that occurred on the porch where this picnic table also happened to be. It's not an extremely large porch, as you can see.
It looks like a wraparound. It just goes around. It's not set
Yeah.
up off the ground.
And it's not a very large home. It appears to be some form of like a almost mobile home.
But the picnic table where the picture is not in the front of the house where she's trying to get into the house.
Sure, but part of the assault took place at the door, according to the testimony, but it's not limited to just the doorway. And the point is, again, that this was not, the defense was that this was not a premeditated assault and that there was a reason to bring a paring knife, which I would know is not a knife I would take if I was intending to assault someone, that one of the smallest knives you can find in a drawer. But I think it's indicative here when we look at the reasons given of counsel's complete failure to really apprehend what the defense was, as we've argued in the other issues. With the lack of any clear argument about how things just got out of hand could justify a jury finding a theory of a not guilty verdict. We've made an argument there that there's this absence of authority regarding the mitigating circumstances instruction and how it could apply to the great bodily harm, offensive great bodily harm. There is some unpublished case law, but this is a very clear argument made by counsel that this was something that they were honed in on as it got out of hand, but they didn't give the jury the necessary things that they need to render a not guilty verdict, which is an instruction. I do think that my brief kind of lays out both of those issues with the GBH and the mistake of fact instruction. I'm happy to accept any other questions, but I'll just reserve the remainder of my time for rebuttal. All right.
No more questions. Thank you.
Good morning. May it please the court. Assistant Attorney General Brent Morton on behalf of Macomb County. Before I dive into the effective claim, I just want to make one comment regarding the first issue, the jury error. The jury error was a statutory error. It's not a structural error as is claimed by defense. And I would just bring attention to, although an unpublished case, this court has looked at this issue and issued a case on November 24th of 2025 of People versus Bauer, Bauer, docket number 363985, where it analyzed the same argument and said, no, this is not structural. In order to have relief, you have to follow the statute, which is under MCL 600.1354, paren 1. You need to make a timely objection and have actual prejudice, and there needs to be substantial noncompliance. And in that case, it was all found that was not accomplished. And I would argue under this case, it's the same.
You're talking about issue 1, right?
Yes.
Okay, so was it preserved for appeal by filing the motion to remand?
No, to preserve it under the statute, it needs to be done at the time that the jury is selected at the trial.
All right, so what is our standard of review then?
It's an unpreserved issue, so it's plain error.
Does this happen all the time? Is this how they always do it in Montcalm County?
Anecdotally, I think that there's been a few cases where this has occurred, and hopefully now the decisions are going to get down there and they may change the way they're doing things. But
There had been at least one other one that I came across.
there have been, I think I'm aware of 3 times
Okay.
where this error was done.
I was thinking they probably changed the way that they're doing it.
One would
I'm
hope.
hopeful.
One would hope.
Maybe follow up on that one, Mr. Morton.
I should do that. Thank you. With regard to the ineffective claim, I believe in the Ginther hearing, the attorney said, look, I thought about introducing that picture, but it doesn't corroborate the story. It corroborates that she set those out after the fact. And as I blew up the image, there's no evidence that the knife was ever used with those items. So she brought them, she set them out before the police arrived. But the scuffle, you're right, Judge Feeney, the scuffle happened at the door. The struggle happened at the door, not by the picnic table. Furthermore, I believe the defense attorney indicated that, well, if she's sitting on one side of the picnic table because she claims she was snuck up on by the caregiver, then there's a big flower pot in the way, which would inhibit that. If she's sitting on the other side of the picnic table, she could see the house and see the door, and there couldn't be snuck up on. So I think you have a defense attorney who was in a situation where the defendant's story didn't make sense with the evidence. And so the defense attorney did what I think was a good call. He argued jury nullification, even though you're not supposed to get that. He's arguing, look, she's just there to help out her father and she gets attacked. And she wanted the jury they wanted the jury to ignore the facts and the testimony and just say, well, she was trying to help her dad out, so we're going to let it go.
But her dad told her to leave.
Absolutely, yeah. I mean, that initially they hid back in the house, and then the caregiver said, look, she's blocked me in, ask her to leave or ask her to let me out so I can leave. She tried to diminish the conflict, and he went out, and that's when the fight was on. According to the testimony, I wasn't there, we weren't there. So I'm happy to answer any questions, but I really don't see where we should be blaming the attorney for making strategic decisions about what to argue, because it's presumed accurate. And that photo doesn't exonerate her. It actually feeds into the theory the prosecutor argued.
So I'm going to ask you a question. Feel free to say you don't know if you don't remember the case.
Okay.
But so Michigan Supreme Court issued in 2008 People v. Miller. And that was an issue regarding a felon who sat on a jury. And ultimately, the Michigan Supreme Court said that wasn't a structural error because there's no constitutional right to have a jury free of convicted felons. But how is this case, which is based on error pursuant to a statute, how is this the same or different than Miller?
Well, I don't know the Miller case.
Okay,
I
that's
I
fair
would
enough.
just say that I think that this is different than like Yarborough is what I believe they relied on to say, and that was a case where they didn't allow them enough preamps. And the court in that case said, well, that is structural because that goes to the structure of the trial. Defense attorneys are allowed to have certain preamps. In this case, it's statutory. It says, well, we're not going to let a juror serve within 12 months. It's not a magic number. So 12 months and a day is okay, but 11 months and 20 days is not okay. It's not constitutional. It's a statutory error. And then the statute, the legislature said, well, look, in order to bring this claim up, in order to upset a verdict, you've got to follow the statute. That's why it's not structural.
Can you give me that citation to People v. Bauer again, please?
Absolutely. People v. Bauer, Bauer is B-A-U-E-R. That's an unpublished case, was decided on November 24th of 2025. And it's docket number 363985, pages 7 to 10.
Okay, thank you.
Thank you
Any
very
other
much.
questions? Okay. So I'll ask you the same question. If you don't know, just let us know. How does this case, as far as structural error versus no structural error on the jury issue, how does this case compare or contrast to Miller?
So I think it's more in line with the type of error you see with Yarborough. Yarborough was not a constitutional violation. It was a violation of the peremptory challenge procedure in which once jurors made their way to the box and there was a pass for peremptories, the judge would not allow the attorney to use the strikes on the attorneys, or not the attorney, but the individuals that were still in the box. Not a constitutional violation, but something that goes kind of to the core of the trial process. What we have here is Montcalm County. I'd also note that Ionia County engages in the same procedure. It's on their website that this is what they do and how they conduct this. So I don't think there's any indication that they have changed this, and it seems to be a continuing practice. It might be because the county is smaller and that's how they have decided to run their resources, but we have laws in Michigan. The other issue here, why I think it's more similar to a Yarborough situation, is that individuals that serve on multiple jury panels together, and one of the reasons we don't have these type of pools where the same group of people are in the same call over 3 or 4 months, is that they serve on multiple juries together and start to rely on each other's interests or whatever they feel about evidence and might trust each other's judgment. One of the things that's lacking, had trial counsel maybe engaged in some meaningful voir dire about this, is, I could think of questions back when I was the trial attorney that I would have asked is, did you serve on this panel with anybody else here? And how does that impact your judgment? Have you come to trust the other members of the jury? And I think what it goes to, and why I think it's closer to Yarborough, is it goes to at the end of the day, the composition of the offense, or not the offense, of the jury veneer. The issue then, I think, with structural errors, I think we've argued it has the hallmarks of structural error. Of course, this is not a preserved issue of structural error, but the People versus Donald Davis case from the Michigan Supreme Court has held that the burden is then on the prosecutor in cases of unpreserved structural error to prove that it's harmless beyond a reasonable doubt, and that's simply not a burden they can meet. Just briefly, unless there's more questions about that issue.
I just wanted, was there any offer of proof that the jurors who had more than one sitting in the courts in Montcalm County within that 12-month period of time had sat together? Your
Yes.
theory? Oh, okay.
Yeah, so we filed a motion to remand, or in the alternative to admit the documents that we obtained from the Montcalm County Circuit Court as part of the record in lieu of remand if the court chose not to grant remand. Those documents show that there was overlap between the jurors that had served on multiple panels together. I think that one of the things that distinguishes the Bauer case, I think, from this slightly, and I may be wrong about this, Jessica Zimbelman, who argued earlier, it's the attorney on Bauer, is that we have an actual record, and there's no reference to that in the unpublished opinion in Bauer, that there was actual demonstrable proof that was made part of the record for appeal that this occurred and how it occurred, and we have that in this case. Just briefly about a reasonable trial strategy. I'm not aware of any law that would suggest that jury nullification is a valid strategic thing that trial counsel does. We argue our cases based on the facts and law, and when a vital piece of information that could go directly to your defense theory that's in the form of a picture was there and easily admissible and something that you could at least have the argument for your client is there, you have the duty to do that and not engage in something as the prosecutor has described it as jury nullification. And unless the court has any other questions, we just ask that this court remand for a new trial or on the alternative for resentencing.
No other questions. Thank you very much.
All right, thank you.
The case is submitted. You good? Okay, case number 6 on the docket. We're calling the numbers 368-043. People v. Solis Reyna.
Good morning, Your Honors. Jacqueline McCann from Sato on behalf of Mr. Solis Reyna. I'm going to use my time today to comment on issues 1 and 3, but of course I'm open to the court's questions on issue 2 as well. In preparing for today, I inherited this case from a colleague, and as I was preparing, one of the things that struck me when I was going through issue 1 is sort of the question of how this court can consider the drunkenness, given that voluntary intoxication is not a defense. And I think the court still can consider it in the context that it's raised here about whether the involuntary manslaughter instruction could be given. It seems to me that the argument for involuntary manslaughter intentionally aimed firearm 16.11 is that this occurred during horseplay between these gentlemen in this car ride or this van ride. And the fact that they were drunk when this was occurring is sort of, an offshoot of the fact. It doesn't alter the fact that this occurred during this horseplay, but it is a background context of why this horseplay got out of hand. And I think there's also no real motive for the shooting. These were all family members, cared for each other.
But how is it horseplay when Mr. Solis Reyna turns to the decedent and says, "I could kill you"? I mean, he said that and the decedent laughed. And apparently that was all that it took.
Comments like that are made amongst friends in various contexts. We don't really mean that we're going to kill our friend when we're joking around. Now, should we be doing that with a firearm in our hand? Certainly not. And that's sort of why the manslaughter and the other 16.10 is gross negligence, but I think they sort of go hand in hand, gross negligence and intentional aiming of a firearm without malice.
But it kind of feeds into it, doesn't it? The fact that Mr. Solis Reyna lost 2 games of pool, pulled a knife on one of the gentlemen, said, "We're playing another game." So he was really upset about that. Upset that Mr. Dumas was going to leave the party.
So the gentleman in issue 2, I think Mr. Demas, you're correct, Your Honor, is not the victim of the shooting. And he did have some anger with that gentleman, but there's no indication of sort of this lingering anger or that it would be directed at the decedent, who was his very good friend and cousin.
But it's still, there's the overreaction piece. Let's talk about that, because you lose 2 games of pool, you pull a knife on somebody. Then somebody says they're leaving the party. You're not going to leave. And he shoots his tire out, and they leave with a flat tire, which is kind of amazing. And then he makes a statement in the van, and the decedent laughs, and that's it.
Well, of course, Your Honor, we do have issue 2 saying that the 404B evidence shouldn't have come in, but setting that aside and answering your.
Is it really 404B?
There's no res gestae exception to 404B. So we argue that it is 404B that wasn't properly noticed. But Judge Feeney, sort of getting back to your question, we're not suggesting that there's, we didn't raise an insufficient evidence claim that if you viewed the light in the most favorable to the people that there should have been a directed verdict. There's certainly evidence that supported going forward with the second degree murder and I think the first degree murder charge. But the question is the test met for whether involuntary manslaughter should have been given, and it's in an IAC context, so ineffective assistance for not asking for it. And I think that the test is met. But we don't have to show there was insufficient evidence under that test to show that it was denied a fair trial by lacking the involuntary manslaughter instruction. The jury should have been able to decide those things under proper instruction, and they didn't have this option.
Put something about voluntary intoxication not being a defense.
That is my understanding, Your Honor.
So if voluntary intoxication statute that we have now that says it's not a defense took place after this crime.
Even better, Your Honor, and that probably should be in our a brief, and voluntary intoxication should have been requested as a defense.
But it wouldn't be a defense to what he was convicted of, right? Because second degree murder is a general intent crime.
Is a general intent crime? I would have to go back and look
Yeah,
at the
okay.
voluntary
All right. Yeah.
voluntary intoxication case law as
Okay.
to what occurred before the
Right, it used to be, if I tell you, it used to be a defense to specific intent crimes. First degree premeditated murder would be a specific intent crime, but.
And he was
second degree
acquitted of
murder
that.
would not.
Yes.
So the court would have instructed in that manner. So I'm curious as to, you think the provocation, what element does the intoxication, what?
No,
part of
what I'm suggesting,
establishing
Your Honor, and I
voluntary
apologize if
manslaughter-
I
No,
messed this up, is
No.
I'm saying that even though voluntary intoxication itself wouldn't be a defense that we would ask for an instruction on.
Right.
I think in the context of how it's argued here that this was really involuntary manslaughter, you could set aside the fact that they're intoxicated.
So how,
This
okay,
was
so
horseplay.
provocation. Oh, so.
So not voluntary manslaughter, involuntary.
Involuntary, okay.
But isn't the problem with that argument, though, that at trial, the argument was essentially that the decedent picked up the gun when he was still alive and shot himself, killed himself. That was the argument made at trial, was it not?
Don't have as much familiarity with the record as perhaps I should, Your Honor, but it was my understanding that there were sort of multiple avenues where one could reach reasonable doubt.
Okay.
In that perhaps the cousins the gentleman who testified against our client, I believe, were brothers, whereas our client was the cousin. And so part of the theory is, at least that we're advancing on appeal, is that perhaps their testimony is suspect because they're protecting each other. They would not have wanted to admit that one of them shot as opposed to our client.
But what wasn't argued at any point in time, as far as I can recall, was that somehow like he was careless with the gun and it went off and killed this gentleman. So wouldn't you need some type of argument in the trial court along those lines to get involuntary manslaughter instruction?
My understanding is that the defendant testified, and though he doesn't remember what happened because he was so drunk, he doesn't believe that he would have shot his friend and cousin.
But I thought that not the forensic, but the medical examiner said it wouldn't be correct because he was shot between, I think it was like 12 inches and 4 feet away. That was the distance the gun to the decedent's body. And he said, well, it doesn't support the decedent killing himself because if you're going to shoot yourself, you put the gun up against your head. You don't hold it out like at arm's length, like a selfie, and then shoot yourself.
So there's, I believe, at least 5 people in the van. So I don't think that it's limited to he must have shot himself.
No, but I think it was one of the points that was brought up.
Yes.
Okay.
So defenses can be raised in the alternative, like for instance, one can raise self-defense and manslaughter. So even though one argument may have been emphasized, if there was enough in the record to meet the test for instructing on involuntary manslaughter under either 16.10 or 16.11, one is gross negligence, one is intentional aiming of a firearm without malice. And so that is the first issue. Issue 3 is this is pre-guidelines, right? So this is judicial guidelines.
Can you talk about that? Because this is under what, the second version of the.
This would have been the
judicial guidelines?
1988 version or second version of the
Right.
judicial
Okay, so
guidelines.
what would be the appropriate standard of review? I mean, we've not
Milborn.
Okay, that's, all right, because we went from there to mandatory sentencing, statutory guidelines to all the case law that we now have that creates the presumption if it's within the guidelines. Is any of that applicable here, or is it just Milborn?
It's just Milborn.
Okay,
It wouldn't be, you wouldn't be precluded today if this was present day because of, I want to say Bursich might be the way to pronounce it. Posey and Bursich, but this is back then, this is pure Milborn.
all right, I wanted to see what your answer to that question was, but go ahead.
And I think what happened is the judge focused on one aspect, which was that he left the country. And that sort of overwhelmed the judge's decision-making. And that's not what Milborn or even the Snow factors require. You have to balance the characteristics of the defendant and the characteristics of the offense. This is not the worst second-degree murder I'm sure that any of us have seen.
But
It's tragic, certainly.
I mean,
It's
but
murder, if you believe.
The shooting happened, and then he says, go someplace we can dump the body. The driver doesn't want to go. He threatens the driver. They go, they dump the body out. They go home. He goes and tells his wife, I'm leaving. He goes and gets another van. He drives across the country, escapes to Mexico, and is there for what, 28 years?
Right, and he tells that person, I killed somebody, so give me
That's
your,
what he's been told.
give me
that
your
that He
van.
did it, yeah.
I'm taking it. So-
Those are all things in the record, yes, but there are other things in the record too. They have to be weighed. When he does go back to Mexico, he lives crime-free. The pre-sentence report doesn't indicate any crimes in Mexico. The sentencing memorandum doesn't indicate any crimes in Mexico. As far as I know, nobody objected and asked for an evidentiary hearing, but the judge says, well, I don't really know that this is accurate. But that's not how due process works. If the judge wasn't sure it was accurate, there should have been a hearing. So he is a person who has not committed crimes since that time. He lived openly in Mexico, worked at this, I think, the same factory for a couple decades, lived a normal crime-free life. Does it cancel out completely the crime? Of course not. But it has to be balanced, and going to the top end of the guidelines means that the judge canceled out everything else and focused on those few aspects of the offense and him leaving. And that's just not how Milborn proportionality is supposed to work. This was not a top end of the guidelines crime and offender under the circumstances. So thank you, and I'll reserve any.
Thank you.
Good morning, Your Honor. Excuse me. Good morning, Your Honors. Paige Petrosky on behalf of the people.
If you wouldn't mind starting out answering Judge Ledica's question that she posed to counsel, which is what's the standard of review here?
Admittedly, I was, and during that questioning, I realized that, oh, I definitely did analyze this under the under the standard of review that would be in place for at the time of sentencing.
I think Ms. McCann and I may have lived through it.
I was going to say, I would just note
think
that
that's why when you had the 25-year period, we get thrown back. So that, I mean, I happen to think that she correctly answered that question. I think we go back to Milborn because that's what it was back in the day.
And that sounds, I mean, from without going back through and double checking that would comport with my understanding too. And so, but I would just note that even under the earlier standard or under the present day more lenient standard, or not more lenient, excuse me, but the standard in which essentially
There's a presumption of.
there's the presumption of
proportion-
proportionality that can be rebutted. Even under that standard, it's very, very clear that the trial court did not impose an unreasonable sentence. The court on the record considered each of the Snow factors and did not just focus on the fleeing for 27 years, but also noted on the effect of on Mr. Amijo's family. The lack of remorse that was demonstrated by the refusal to turn himself in, and also just the danger to the public that the defendant posed by the fact that just, becoming intoxicated would be sufficient for him to kill, a family member or a close friend. And so for that reason, under either the Milborn standard or under kind of present day, it's very clear that the standard was appropriate, proportionate, and reasonable to the circumstances of the defendant and the surrounding offense. Just briefly touching on the involuntary manslaughter jury instruction, I would note that trial counsel did request a jury instruction for voluntary manslaughter and that request was denied because there was just so much evidence that defendant acted with at least the requisite malice for to support the first and second degree instructions, but that a voluntary wouldn't be appropriate. And then the even lower level with even less malice or less culpability required, it would follow that would have been a futile request to have made for trial counsel to have made. And it would have potentially, as was noted earlier, gone against what trial counsel's theory of the case was, that it was either a suicide by Mr. Armijo or that there was some sort of mass conspiracy between these brothers and some random guy that the defendant threatened to give him the yellow van so he could flee the state. Somehow all of these people whose stories are corroborated that they are in this conspiracy. So those were the sort of two avenues. And this jury instruction wouldn't have comported with either of those theories. And so if there are no other questions, I'll rely on the briefing.
Other questions? Thank you.
Thank you.
And Ms. McCann, I did not mean to date you, but I know
That's okay.
we are somewhat contemporary, so
I think we did get to practice together for a while.
yes.
So I would just, a few brief comments. I believe they turned down, the judge turned down the voluntary manslaughter instruction, not because there was no provocation, which is sort of part of the point of why the involuntary is what should have been requested. On the sentencing issue, I would just again go back to the Snow factors, which are reformation of offender, protection of society, punishment, and deterrence of others. Two of those go my client's way. He seems to have reformed himself, and there's been no danger to the community since he's been living a family life, working a job for 20 some years in Mexico. There does need to be punishment. There does need to be deterrence. But again, there has to be a balancing under Milborn, and going to the top end of the guidelines just doesn't consider the first two factors.
Didn't the trial court decide that he was a risk to the community because all it would take is him getting drunk?
I think that is considering him as a 25-year-old in 1995 and not considering I guess what would be some 50-some-year-old when he was before the court. His time did not stop. He was not 25 years old and it was not 1995. The whole picture needed to be considered. Thank you.
Thank you. That matter is submitted, and we are moving on to the next item on the docket, which is number 7374452, People v. Walzer.
Good morning. My name is Craig Elhart. I was the trial attorney in this case and also the appellate attorney. This case arises out of a conviction out of Oscoda County. It is my understanding that there are two active attorneys in Oscoda County. One is the prosecuting attorney and one is the judge. This is in fairness and openness to the court, this is the third case of three that were charged against Mr. Walzer. The first two were CSC ones. Those cases were dismissed prior to trial because of lack of proof. This case then proceeded to trial on the granddaughter who alleged that this matter occurred in 2017. first reported to police officials.
2021.
Say again,
She first reported in February of 21.
to a therapist in
That's correct.
2021,
Yep.
to law, I'm sorry, go ahead,
No.
to law enforcement in 2022.
Mhm.
Is that correct?
Mhm.
Oh, good. Yeah, this case eventually went to trial, and the judge sentenced Mr. Walzer 5 to 15 years.
Right.
And rather than the recommended on the OV statutes over the
12 to
sentencing
12
guidelines
to 24.
to 12 to 24.
Mhm.
By the time we got to trial, Mr. Walzer had served over 2 years due to different difficulties that he had regarding bond.
Well, and he kept violating bond. I mean, he wasn't supposed to have any contact with the victim or the victim's family. And he was like making threats and saying, if you don't, get her to tell the police this is a lie, or I'm going to divorce your mom. And boy, it was something.
It was something, wasn't it?
It really was. Honestly, I had never seen anything like that before.
Well, I've been in trial practice for 50 years. Unfortunately, I have. It doesn't happen in a vacuum. Many people, particularly Mr. Walzer, who at that time was 85 years old, suffering dementia and heart issues, just didn't get what he was supposed to do. Don't think I didn't tell him. I did.
I never presume that, honestly. When you have, clients behaving badly, I never presume it's anything that the attorneys told them to do.
Well,
So-
I make a real effort to keep people in the box during the course of litigation. And this is one of those instances where he just couldn't stay in the box. That having been said, he did wait 2 years incarcerated for trial. The bond issues were taken care of. This judge, and let me also say, it was one of the finest victim statements that I've ever heard. The elocution by this young lady was tremendous.
Yes.
She did a wonderful job by making the statements that occurred. That having been said, in listening to that, we listened to that in a bit of a vacuum. And the vacuum is that she's focused in right then and there on what happened during this one incident, not the rest of her life and the effects that the rest of her life had on her, as an example, losing her father at a very early age. So there's a number of things that go on. Now, you've got to remember that what Mr. Walzer did and has been convicted of were 3 touches that occurred outside of the clothing. And those 3 touches occurred within a very short period of time. When asked to define the length of time, she was unable to do so, other than it was a very short period of time. So we had 2 taps on the bottom and a tap close to the genital area. And those are the 3 CSC1s, or 3 CSC2s, I'm sorry, that he's alleged to have occurred.
But didn't he also,
Kissed her.
he French kissed her
He did.
while he was grabbing her butt
He did.
and touched her genital area over her clothes and grabbed her butt a second time.
The seconds, however, both were the touching of the bottom and the genital area.
Yep. But that happened within maybe less than a minute. So
Correct. A very, very brief period of time. Nevertheless, there's a conviction. I get it. We're all there. Sorry, I can't hear you, Judge.
Oh, your client is entitled to maintain his innocence as he did below. He claimed that this was a false accusation and he was 100% innocent.
That's
That
accurate.
is right. That he has every right to do that.
He got on the stand and testified, and his testimony, frankly, wasn't the best. I wish it could be better, but unfortunately, when you're at that point 85 years old, now 86 years old, sometimes you don't always do what is best for you. Nevertheless, again, her allocution, her victim statement at allocution was excellent. She did a wonderful job. And the judge, I think, overstepped her bounds by way of OV4 and OV12 particularly. OV4 talks about the psychological impact. He was scored at the highest psychological impact that you could score, which is 10. She said it went beyond 10. I don't know how you can do that, but that's where we go. So I think that we're in a situation where this should have been, I can't and will not and won't defend his actions. That's inappropriate to do so. That isn't who I am. It isn't what I do. I am defending his rights, and his rights, however, are subject to the sentencing guidelines that we put forth. The reasoning for the sentencing guidelines, as they originally were anticipated, was to keep parity between northern counties and southern counties with how you charged and how you sentenced. And it didn't happen in this case. Had this been in Oakland County, Monroe County, Detroit, we would have been to 12 to 24. This judge looked at this and sentenced far in excess of what the guidelines should have. Made a number of statements that put this in an onerous level, in my opinion, and this should be reversed and sent back.
But I mean, in her allocution, the victim detailed the impact that all this had on her. He was a trusted individual. He was her grandpa. She couldn't trust people after that. She was failing school. I believe there was self-harming. She was diagnosed with PTSD, violent nightmares centered around the assault and the defendant. She she couldn't stand to be awake. Oh, that's right. She would sleep all day. She'd come home from school and just sleep because she couldn't be and dealing with it. She was either sober or had some variant of intoxicated darkness. So she called it either sober hell or some variant of intoxicated darkness. That's when she was 15 and 16. Talked about delaying her education, behind in her college degree, all the rest of it, because before she was a really great student. So I think she really laid it out on how this act completely derailed her life.
I absolutely concur with you. I said that originally, that this was probably the best allocution that I've ever heard from.
But don't you think that
Go ahead,
I'm sorry, with the OV4, that you said, the judge said it really didn't fully consider the complete impact of defendant's actions on her. So isn't that one way? Don't you think that that's what the judge was referring to? That there was just so much that happened. It's 10 points.
But OV4 is scored at 10 points. That's a maximum that you could score on serious psychological injury.
She had serious psychological injury. I mean,
So she got the 10 points.
okay.
And the question is whether or not this should be then 2.5 times the amount of what the sentencing guidelines are, and I don't think it should be. This is a situation where we weren't allowed and didn't inquire into the rest of her issues that were behind her. Did she lose a father? I think she testified at trial that she did lose her father during the course of this. She had a number of things that were ongoing. Are all of them attributable to this less than a minute of touching? I don't know that. We will never know that. That's the reason for the sentencing guidelines, to give you a maximum amount, which is what she got.
But there was the subsequent touching when he touched her bottom after the initial touching sequence. He walked by her and patted her on the butt.
Alleged out in Genesee County. That's correct.
That's right.
Yeah.
Okay.
Yeah. That has never been prosecuted and perhaps never will, but.
Makes sense.
All right. Any other questions? Judge, you've been strangely quiet.
Oh, wow.
That's a compliment.
I'm just wondering, because I was looking at something here, trying to find, has there ever been, and forgive me, this may be apparent in the record, but has there ever been a dementia diagnosis of your client?
His physician has, not within the record, but his physician has indicated to me that he does have dementia.
Okay. Thank you. Any other questions?
Which I never know if it's accurate or not.
Yeah, sure. Understood.
Was that part of the pre-sentence information report?
It was not.
No.
Morning again, Your Honors. Nick Johnson, Assistant Attorney General, on behalf of the people. Judge Wallace, I tried to follow up on your question regarding the dementia diagnosis, and I do not see one in the pre-sentencing report, so
Okay, thank you.
I can't speak to that. Obviously, this court is well aware of the facts. Judge Feeney recounted a lot of the same points I was going to make in my rebuttal.
Sorry.
Took a little wind out of my sails, but that's okay. The only other thing I guess, or I just want to note too, it wasn't just the touching. Before the touching, he had told her that she was getting very hot, and she might have even used the word hottie. And so I think you're looking at that from a person who you believe, I think he was characterized, the defendant was characterized as the victim's hero. She was a, vulnerable victim. She looked up to him, obviously. And so to be not only sexually assaulted, which is very severe, but to also be framed in that way was very serious. And I think the trial court recognized all that, including factors that were not adequately considered by the guidelines. You look at OV4 and Judge Feeney, I know you noted too, the 2021 incident, and the court did make a finding that it was only sentencing the defendant on this specific instance. But you look at that and how it re-victimized her, and that added to the trauma that she had experience. Obviously, she was self-medicating with drugs. She was having problems with school. She gets re-victimized by the same defendant a few years later, and she goes right back to square one. She's, again, struggling in school, having these issues. So I think really that lends credence to the fact that OV4 scored at 10 points did not give adequate consideration to what her psychological trauma was. And then you look at other factors. This court in Walden said you can look at other factors that aren't considered by the guidelines. And again, family relationship, you look at his misconduct while he was on bond, obviously violated twice. That's the reason why he had so much time accumulated, was because he was violating his bond with the same victim. So, and then lack of remorse as well. So ultimately, I think the trial court explained the reasons as to why a within the guideline sentence of 12 to 24 months was not sufficient for this defendant, and did not abuse their discretion in extending it to 5 years minimum. So if this court has any questions, or I'd be happy to try to answer them, but it has to affirm.
No questions. Thank you.
Thank you, Judge.
Okay, that case is submitted.
Oh, is he gonna do
No?
rebuttal?
Oh, sorry. I forgot about the rebuttal. That case is not submitted. Go ahead, counsel. I'm sorry about that.
Very briefly, look, the psychological, what he did was bad. And I'll be the first one to say that. But that isn't the problem here. The problem is the double dipping of OV4. The familiar relationship was already charged. The bond violations had been dealt with separately. All of those things are things that the prosecution has now brought up, and all of them were separately taken care of. Thank you.
Counsel, can I ask, was the family relationship, was that OV10?
No, the family relationship is in the charging as to CSC second.
But was it taken into account in the guidelines?
It is not.
Okay. All right.
There's nothing
I wanted
within the
to-
guidelines that
in light
would
of Judge
indicate
Feeney's
it's the
question that-
charging relationship only. Thank-
Okay, I understand your point now.
Thank
All
you.
right.
Okay, now that case is submitted. Thank you very much. Have a good day, gentlemen. We are now turning to case number 8 on the docket, number 366091. People v. Lakatos.
Good morning again, Your Honors. Jessica Zimbelman from the State Appellate Defender Office, subbing in for my colleagues today on behalf of Evan Lakatos. Mr. Lakatos is in the courtroom this morning with his parents. Wanted the court to be aware of that. I have been doing this a very long time and have seen a lot of injustices over the years that my clients have suffered. But it's hard to put into words the egregiousness of what happened to Mr. Lakatos here at the hands of the police. This court, before I get into the arguments, this court, of course, is familiar with Jade. I know Judge Ledica was on the panel for Jade here. And that, of course, is pending in the Michigan Supreme Court right now.
They held oral argument.
They held oral argument. That's correct.
It appears that they have thoughts.
They have thoughts. Yes, they do
Yes.
have thoughts.
They're going to be setting forth, I think, some standards. What our standard of review is. Do you have thoughts about whether or not we should hold this in abeyance for Jade?
it makes the most sense to me, especially given that that opinion will likely be out by July 31st, and we're already at May 12th. So perhaps there would be further additional guidance for this court. But even if this court
I mean, there are some factual differences as well.
there are
this
factual
and
differences
but-
in Mr. Licatos's favor, and I was going to get into some of those distinctions that even if the Michigan Supreme Court upholds this court's opinion in Jade to the letter, Mr. Licatos is in a different situation. And I want to talk about that for a minute. First, we know that there are two ways that Mr. Licatos could have been entrapped by the police here. Both of them happened. He could have either been induced to commit a crime, or the police is engaged in conduct so reprehensible that it cannot be tolerated. Both of those occurred here. The police made up a crime. They manufactured a crime here that Mr. Licatos would not have committed but for his interaction with the police. Mr. Licatos was ready and willing to engage with an adult male on Grindr. And it's interesting because, and I rewatched the Jade oral argument to prep for this morning, the Jade oral argument in the Michigan Supreme Court.
I viewed it myself.
And the court there also acknowledged in Jade, it was Skip the Games, which is an adult escort service. That's what it purports itself to be as a website. Chief Justice Kavanaugh acknowledged in the Jade argument that Facebook, Instagram, and a dating site like Grindr.
They discussed the situation.
So that is one factual distinction as well between Jade and what happened here with Mr. Licatos. Another factual distinction that matters from Jade is that the only reference to age that the police gave here, the decoy, was when the police officer said, my cousin finally got
to rent the hotel room because they won't rent to a 15-year-old.
Yes, my cousin finally got the room for me. I guess you have to be older than 15 to get a room. So that right there is unlike Jade, where the decoy said, I'm 15, I'm actually 15. Like said those words explicitly. We cited in our brief 2 other unpublished cases with these sting operations, which this court knows are like wildfire in this state. All over, every corner of the state, the police are engaging in these sting operations. In Stepka, the decoy said, I'm 15. You're cool with me being 15. In Newbie, the decoy said, I'm really only 15. So there were much more explicit references to, I am this old.
And you're saying that that has to happen? Because I thought there was another reference during the conversation as to whether he liked young guys.
He absolutely did say he likes younger men, but that he didn't say kids or minors. He said younger people, and he himself was 34 years old at the time.
Mm-hmm.
So theoretically anything less than 34. And this kind of gets to the reprehensible nature of it. At the evidentiary hearing here, the police testified that there are protocols that they have to follow when engaging in one of these sting operations. First, the suspect is the first to initiate communication. The suspect is the first to bring up sex. The chatter or the decoy must state that he or she is under the age of 15. And then the suspect must acknowledge that the chatter or the decoy is under the age of 16. Those are protocols that were not followed here. And that gets to the reprehensible nature of the police conduct. There are policies in place in these stings so that they don't entrap people. So when the police aren't following their own policies, that is reprehensible. And we as a society should not tolerate that. Our police are out there making up crimes instead of actually protecting the public from people they need protection from. Mr. Licatos had no prior record. And it really doesn't matter because for the purposes of an entrapment analysis, we are instructed and must look at the conduct of the police, not whether a conviction happened, whether there's propensity evidence. It is the conduct of the police. And here it was reprehensible and it induced an otherwise law-abiding citizen to commit a crime.
So I thought it was Mr. Lakatos, who was the first one who initiated, because you said the suspect is the first to initiate, right?
Yes.
And that happened here, correct?
It looks like from our briefing on page 9 that Mr. Lakatos said, "What's up for your day?" So he appears on Grindr to have established the communication.
All right.
However, the decoy, the cop, is the one who turned this conversation sexual, which is a violation of the protocols in these sting operations.
And that's based upon, I'm trying to find, it's not in the briefs, it's in the attachment where they wrote out, there was the one exhibit with all the phone, right?
Mhm.
And then there was an other one that had all the statements
Mhm.
contained in it. And you're saying, so,
So if you look at page 9 in our brief, there is a verbatim, the exchange.
sorry. Okay. So what are you saying was the first?
The first sexual, where this turns sexual, is when the decoy, who is labeled as Taylor, says at 4:23 p.m., "I want the dominant man to tell me what he wants." And then there's the heart face emoji. That is when the conversation turns sexual. There's also, I think, even before that, the decoy is talking about his comfortable bed, and there's some other innuendo. But the suggestion that the dominant man, which is a sexual term, that opens up the sexual connotations. The police also in this conversation escalated the criminal conduct because the police were repeatedly asking Mr. Lakatos to bring White Claws, to bring alcohol. The police were not sending a picture of the decoy as Mr. Lakatos continuously requested.
Okay, but I'm going back to your first statement because the what's up with your day is Mr. Lakatos. And he said what are they called? The chatter?
The chatter, the
C-H-A-T-T-E-R.
decoy, yeah.
Just hanging out today. And then Mr. Lakatos responds, he's back here at the hotel to relax. The chatter, I'm getting a hotel tonight too. Nice, Mr. Lakatos. Big Rapids here, Mr. Lakatos. The chatter, I'm in Fremont, don't have wheels. Mr. Lakatos, not too far and would be fun to hang out. Then the chatter, I hope you like younger boys. Mr. Lakatos, yes. Then there's pictures. There's a request for pictures.
And if Your Honor is thinking that not too far and would be fun to hang out is somehow sexual, it's really important that Your Honor remembers that this is a dating website.
Mhm.
This is not like Skip the Games where a sexual hookup might be expected because it's a site you go to hire escorts. This is a dating site. Mr. Lakatos, there's nothing sexual about saying, let's hang out. That could be a multitude of things, as we all know.
So then you're saying the chatter's next comment, I hope you like younger boys. You say that's sexual?
No, that is not sexual.
All right.
I think where it turns sexual is where the chatter at 4:23 p.m. onto page 10 of our brief says, "I want the dominant man to tell me what he wants."
Okay.
And that alone there goes to the reprehensibility of police conduct here.
So and you don't think that I hope you like younger boys and Mr. Lakatos saying yes is okay.
Not on a dating site.
Okay.
And that's really, it's kind of hard to take us out of the mindset that this decoy is pretending to be 15, especially when the pictures, as Your Honors have seen, are of an actual 27-year-old man. And that's another distinction with Jade. I believe the female police officer was 18, but this decoy officer, where they posted his pictures shirtless of a 27-year-old man, was intending to create crimes where none existed. Mr. Lakatos, as I said, the ready and willing is a component of of these, of determining whether a person was induced, Mr. Lakatos was ready and willing to meet a man to date or hang out with or spend time with on a perfectly legal adults dating website. That's what he was willing to do. And the police intervened and made up a crime. And Mr. Lakatos has had to suffer the consequences of that since then. He's a tier 2 registrant on the sex offender registry, not to mention felony convictions and jail terms and public shame that has come from a manufactured crime. This is all based on police conduct. And it really is a distinction from what happened in Jade. Although I do think the Supreme Court will give us some guidance on how these are supposed to be reviewed. Because essentially, again, we focus on the police conduct. The officers used images of a grown man to lure unsuspecting gay men in the area who are looking for companionship with other gay men. That's what happened here. The police were not protecting us. They were creating crimes and actually harming people in the community like Mr. Lakatos. The failure to follow their own procedures, again, gets to reprehensibility. The Supreme Court in the Jade oral argument also talked a lot about that. Why do we have policies if they're not going to follow them? Well, that gets to reprehensibility. We cannot live in a society where the police engage in conduct like this with the intent of manufacturing crimes. If the court has no further questions, that's all I have, and I'll save the rest of my time for rebuttal.
No questions.
Morning again, Brent Morton, Assistant Attorney General on behalf of Newaygo County. With regard to if the court should wait for the Jade decision, I think it is going to be instructive. I think it would make a lot of sense to wait for that decision to come out. I would ask that we get another round to do briefing if that makes a difference and you're relying on the Jade decision. So that we may have comments on it. Just to hit a couple points that the decoy supposedly moved everything sexual. The site's named Grindr. You go there to hook up. I'm sorry, maybe that's an inappropriate thing to say, but it's a dating app with intentions. And so people are there to find someone to have sexual relations with. So I think that once he makes the contact, he's out on Grindr looking for somebody, and they indicate that I'm too young to rent a hotel room, and he goes, his response was something like, that's not fair.
How
or, That's
rude
rude.
of them.
How rude, excuse me.
Well, he doesn't say he's too young to rent a hotel room. He just says that his cousin rented a hotel room, and it turns out you can't rent a hotel room if you're under 15.
Right, he
It's not
initially
the-
says, I'm gonna rent a hotel room.
That's not the same thing. I mean, you can't rent a hotel room if you're 16 either, or 17, right? You might, in a lot of places, you can't even rent one if you're 18.
In an earlier discussion, he said, I'm gonna rent a hotel room, and then he comes back and says, my cousin had to do it. Because I'm.
Didn't say you had to do it. He said, my cousin rented the hotel room. Turns out, you can't rent a hotel room if you're under 16. Couldn't that mean about 4 or 5 different things?
The jury determined that, this was argued to the jury. The jury determined that showed that was his age. I think it's pretty clear that that's his age.
Well, when you take that into context with that photograph, I mean, first of all, why would they use the photograph of a 27-year-old man? Why would they do that?
I was not in charge of the.
Tell me that's not misleading.
Well, but it is, but I believe one of their experts indicated that they thought it was an underage, the photograph.
Oh, come
of an
on,
underage person.
come on. What 15-year-old have you ever seen that looks like that in your actual life, not on television or in a movie? Have you ever seen a 15-year-old that looks like that has that kind of 5 o'clock shadow and that body that looks like a body of somebody in their late 20s?
I believe the face was blocked by a smiley face.
No, but
The exhibit.
there's 2 pictures. In the one picture, you can see that the person clearly has a 5 o'clock shadow.
My review of them didn't show that, but obviously you have You have an exhibit?
I'm looking at it right here.
Okay.
It's, you can see I don't know which side of his face it is, but you could see the jawline and you can see he's got a 5 o'clock shadow.
But those are issues for a jury
He's
to determine.
supposedly under 16.
And those are issues for a jury to determine, and they determined that it was something that was believably young, a young person. We disagree that it was entrapment. We believe we made this was an offer to commit a crime, and he picked up on it.
I mean, where's the mens rea here? Forget about entrapment. Where's the mens rea?
Well, again, the proof showed he was talking to an underage person. He was proposing sex.
Okay, first of all, the proofs don't show that he was talking to an underage person. You have to show that he believed he was and was soliciting him for sex. So what's your proof of mens rea that he believed he was talking to somebody under the age of 16?
He indicated that during the interview. He indicated that when he was going, he knew it was wrong.
What he said initially in the interview was they said that he had been told that the person was under 16 in the text messages or in the Grindr chat. And he said, no, go back and look. It doesn't say that. And then they essentially said to him that it does. And he more or less said, okay, well, I guess I did that. In other words, they basically they lied to him and said something was in there that wasn't in there. And then he just went along with it. How is that mens rea of somebody intentionally soliciting sex from somebody under the age of 16?
We see the proofs differently, Your Honor.
Okay.
I disagree, but
Does I don't have wheels have anything to do with it?
I think it's indicative of somebody who's youthful, but I don't, again, I think that's some evidence that can come in and be argued, but it's not a silver bullet.
Do you think that they have to come out and say, I'm 15 in order for any of this to work?
I don't believe so. I think that you can talk about being in class in high school, or in this case, he talked about, I couldn't rent, I was going to rent a hotel room, but my cousin had to do it because I'm 15, or because you have to be 15 or 16. I think now if I'm the trial attorney, do I want that exchange? Absolutely. Because it's better evidence, but I don't think that you need that in order to pass some magical hurdle.
I mean, shouldn't we require that though, as a society? I mean, shouldn't we require some type of explicit communication just to make it crystal clear that this person is about to violate the law? They can either go along with it or they can not. And once they cross that line, they violated the law. But I mean, shouldn't we require it to be explicit? The communication that the person's underage.
I think this was explicit enough. And I think the other point that I'd like to make is that the defendant in his interview said, well, I know that not everybody on Grindr is over 21 because I've reported people before. So he was on notice. There's a lot being made out of, well, Grindr's this adult only website.
Well, let's
there's
talk.
no protections.
Let's go back to that.
Okay.
21
Or 19, whatever the age was. I'm
I
sorry.
thought it was 18.
18.
18. Okay. I'm sorry. But he knew there was an age limitation. And he knew that there was no way to check it and it was not reliable.
Okay, so it was 18, not 21, right?
I'm sorry. Yes, that was my mistake.
Don't worry about
And we
it.
know
I make many every day.
We know that people never lie about their identities on the internet.
No.
Anything else?
No, Your Honor. Thank you very much.
Thank you. What's your response to the suggestion by counsel that Grindr is not exactly what you've claimed it to be here today?
Well, I find it interesting for two reasons. First, I did a quick little Google search while I was sitting there at counsel table, and how Grindr markets itself is Grindr is the world's #1 free dating app service servicing the LGBTQ community. What's also interesting, and I know it's not the parties here that are making this argument, but the prosecutor in the Jade Michigan Supreme Court oral argument said that Grindr is somewhere on the spectrum between Skip the Games and Facebook. as far as what it actually is. So I think it's a wild assumption for the prosecutor to say that everybody knows you go to Grindr to hook up. That we don't have that in the record. It is not here. And quite frankly, it's not really relevant because again, we look at the conduct of the police. The police here lied about their identity on the internet, as Judge Letica just pointed out that people do, and posted the pictures of a 27-year-old man to lure men and to induce people into committing crimes. I also want to talk briefly about the interview as some sort of evidence that Mr. Licatos had the correct mens rea. I wrote down exactly what he said. The police officer said, "We know that the person you were communicating with told you how old they were. We know they told you that they were almost going to be 16. We know that. That is a lie. We know that, correct?" And so then the police said, "Be honest with us, help us out, cooperate. We know this was a mistake." And then Mr. Licatos said, who, if you watch the interview, is visibly shaken the whole time at this interview. He says, "Yeah, they said they were younger." And then the police, again, "Just be honest, okay? We're gonna go through it all." And then Mr. Licatos says he did say he was under 16 or about to be 16, which essentially parroted back the lie that the police had told him. So not only was the police's conduct reprehensible in posting this and inducing Mr. Licatos into committing a crime he would not have committed but for police actions, their conduct during this interview was also reprehensible. And to suggest that he write a letter of apology and then to feed him the more words that he needed in this apology was also reprehensible and led to a statement that Mr. Licatos thought was an apology that turned into a confession. And as far as the prosecutor saying here today that it's a jury determination about age, this should not have made it to the jury. This case should have been dismissed on entrapment grounds before this case even started. No jury should have been in the position to make a decision whether Mr. Licatos knew for a fact that this 27-year-old cop was actually a minor. And I thank you for the court's time this morning.
Thank you. Thank you to both of you. It's a very well presented case on both sides. Thank you. Okay, that case is submitted. We're going to turn to the last case on our 10 o'clock docket, which is case number 9373496, People v. Adams.
It's officially afternoon, so I'll say good afternoon, Your Honors. My name is Chloe Bruick from the State Appellate Defender Office on behalf of Mr. Jerry Adams. Your Honors, I'd like to focus today on the first and third issue. And with regard to the first issue, I just want to bring to Your Honor's attention a couple cases that have come out since we filed our reply briefs in this case. The first is with regard to illegal parking, and
Are they published?
sorry, this one is not published, no. An unpublished case. Or, excuse me, this one is published. I apologize.
So it might be helpful to submit supplemental authority.
Sure, it's a civil case, so it's not directly on point. It's more about the definition of legal. Sure, yes, I would be happy to do that, Your Honor.
No, go ahead. I mean, we're here now, so go ahead.
The case is called White versus Pace. There's no reporter number yet. It's docket number 371878, came out in November.
37178.
Thank you, Judge Feeney. And it analyzed the definition of parking in the Michigan Motor Vehicle Code and ultimately upheld that the definition of parking is standing, but just called into question the validity of that definition and that it's, quote, extremely troublesome and would seem to indicate that someone can be parked while motionless at a traffic light. And so applying that to this case, all the cars who were lined up in this case to turn into the parking lot could have legally been given a citation for illegal parking if they were at a traffic light in the exact same spot.
But they weren't. Right?
Right, but
They weren't.
They were not, there was no traffic light, no, but
Right.
they were within the flow of traffic
And
waiting.
there were signs, right? Were there not signs?
There was a no parking sign, Your Honor, but
Okay.
they were waiting to turn into the parking lot in the flow of traffic.
I mean, what that argument really amounts to is as applied challenge to the constitutionality of that statute, but that hasn't actually been briefed here.
No, Your Honor, and I'd be happy to submit supplemental briefing on that point. I just wanted to call Your Honor's attention to the questioning in that published case of the definition. And then the second case I just wanted to talk about, this is an order from the Michigan Supreme Court, so more so for guidance, and this is about excessive force. The case is called People versus Ford. The Michigan Supreme Court docket number is 169-177. And that case is about how to apply Moreno in an excessive force case. The court there in the Michigan Supreme Court denied leave because the facts didn't fit with the legal argument, but Justice Welch wrote a concurrence talking about how that excessive force can be can negate the lawfulness of officers' conduct in a resisting and obstructing context, and said, under the common law, an officer's excessive force is unlawful conduct that justifies the defendant's resistance, even if the underlying arrest is lawful. And so the prosecutor argued that that's not the case in their brief, and I'd just point Your Honors to that concurrence from Justice Welch.
So that wouldn't be binding on us.
It would not be, no, just for guidance.
Oh, okay. All right.
But so I'm trying to figure out how that works in, because when Mr. Wasser was on the side of the road in this vehicle, the officer told everybody to stay. They're in violation. Then he pulled out of the line. The officer told him to stop. He needed to stay. And he was just screaming at him. Mr. Wasser was just screaming at the officer. And then Mr. Wasser took off, contrary to the officer's instructions to stop and stay, went around the block. So the officer called for assistance. And then after he got done, I think dealing with the other people in line, then they went to look for Mr. Wasser. And he had just pulled around the block and was standing in line at the dispensary versus waiting in his car to get into the dispensary. And it was there that then they approached him. But there were two of them there at that time, as I recall.
Two at that time, yeah.
Two officers there. And he was not compliant with their instructions to come with us.
When they came up to him in the parking lot, Mr. Adams walked right up to them with his hand out and said, "I'm going to talk to you." And Officer Roberts grabbed him and threw him on the ground. And three other officers showed up and had their hands on him while Mr. Adams screamed and asked what he had done wrong as they muscled him into handcuffs. So that's where the excessive force would play into the resisting and obstructing conviction. And unless Your Honors have more questions on the first issue, I'll move to the third issue, which is the prosecutorial misconduct issue. I've outlined in my brief the errors here were plainly improper. These weren't one-off comments. This was a permeation of the entire trial. Of course, the prosecutor could have argued that the streets were often busy as a result of these dispensaries, but the prosecutor went far and above that, telling the jurors to thank their lucky stars if they don't live here, that these dispensaries are changing the complexion of their community, inviting people of all shapes and sizes into their community. And these comments from the outset are enough to violate Mr. Adams's right to a fair and impartial trial. They had nothing to do with the fleeing and eluding and resisting and obstructing charges. It was just an attempt to disparage the jury against Mr. Adams and those who come to these dispensaries. And the prosecutor didn't stop there. I want to make 2 points about these multiple references to Mr. Adams being from Minnesota and that it was illegal to take marijuana back through Wisconsin to Minnesota. The first point that I think is really important here is that there was no evidence that that was what Mr. Adams intended to do. Mr. Adams sure had Minnesota license plates, but the prosecutor didn't know if Mr. Adams was here on a trip, visiting family, on work. And so to suggest to the jury that he was planning on breaking the law by taking it back immediately through Wisconsin, there was just absolutely no evidence of that, and it was improper. But it was also an improper attempt to tell the jurors that Mr. Adams was planning on behaving unlawfully in an attempt to invoke their civic duty or to backdoor in bad acts evidence without evidence to show them that Mr. Adams had been planning to break the law. This case was about whether, again, at those moments in time, whether Mr. Adams resisted and obstructed or fled and eluded Officer Roberts. And this, just like the case in Kia, which is again unpublished, we analyzed it and attached it to our brief, but that was also raised under plain error in the court reverse. And I think that, again, these comments was a permeation of the entire trial, and that was plain and affected Mr. Adams' substantial rights, and that he was prejudiced. We raised insufficient evidence, but we also raised inadequate jury instructions in our second issue. And so there's reason to believe that these comments pushed the case in the prosecutor's favor. And they seriously undermine the fairness and integrity of the judicial proceedings, particularly because the prosecutor used his office and told the jurors that as the chief law enforcement officer in the county, the dispensaries are changing the complexion of their community. And so using his office to attempt to legitimize these unlawful and improper comments seriously undermine the fairness and integrity. So
I'll mention the same thing that I mentioned earlier. So the jury are instructed that the arguments of counsel are not evidence, and the judge gives them, here's the standards you have to look at. How did that not rectify any potential problems?
I think because this was a permeation of the entire trial. I mean, the very first words that the prosecutor said to the jury were that these dispensaries were inviting people of all shapes and sizes and invoking his status as the chief law enforcement officer. And I think they went even further in Kia by saying throughout the entire trial, and in Kia, the prosecutor there wasn't even the chief prosecutor. And so this had some special status to try and legitimize his opinions about the dispensaries, which again had nothing to do with the case. And brought in all this irrelevant suggestions to the jurors. So a curative instruction was simply just not going to be enough to cure these, again, permeation of the trial, these improper comments. So we'd ask the court to vacate with an order to dismiss Mr. Adams' convictions on the first issue, but absent relief, we'd ask that your honors remand for a new trial. And unless your honors have further questions, I'll reserve.
I have a question.
Sure.
So we've all seen the video. I want you to give me your take on part of the video. So when I see all of these cars lined up, what I don't see is that the entrance is actually blocked by a car. In other words, it's not like this is traffic that's just backed up onto the street because somebody's trying to get into the lot. Instead, when I see the lot, there's no car blocking it. So what was going on here? Was it just the lot was full and each of these people was waiting for one of the cars to pull out so that they could pull into the lot?
I think it's not entirely clear. I think I agree with you, Judge Wallace, that is what the case was, that they were waiting to turn into the business. Yes.
Because the lot itself was full. There was nowhere to park.
I'm assuming that
Okay.
that might have been why.
Okay. Any questions? You know, I had not, until you told us about the White case here today, that civil case, I don't think I had seen it. But as I was reading all of this, in particular, reading the statute with regard to, the pertinent portions of the Michigan Vehicle Code, I was wondering why there was no as applied challenge submitted in this case, but it is what it is. Thank you. Mr. Morton, I hope the good people of the state of Michigan are paying you overtime today.
Oh, no, you're absolutely not. Brent Morton on behalf of Gogebic County. And with regard to the civil violations, I think I outlined 5 totals between civil and local ordinance violations that the officer rightfully could write for citations. Under the law, he's allowed to detain people until the citations are written. So he was acting lawfully. I think in this case, what's unique is we have really good video of how Mr. Adams interacted with the officer. And I think that if there are some errors in this case, I think that greatly overrides it. I think the officer is acting appropriately, so there's no sufficiency issue. With regard to Moreno and excessive force, there's no excessive force here. He instructs him to stop. He tries to get him out of the vehicle. I believe the officer testified that he didn't want to get dragged, so he didn't actually, get a hold of him and have a fight at the initial spot. He let him go when he drove off. And then when they did have contact, he took him in custody because he committed 2 felonies along with the prior civil infractions. So there's no excessive force and it shouldn't be part of the analysis. The other point I want to make is with regard to the statements, they were the prosecutor made arguments about him being out of state because the officer didn't immediately chase the defendant when he drove off because he figured he was leaving the state and he wasn't gonna be able to catch him anyway. With regard to why they're sitting in the street and blocking traffic, Judge Wallace, I'm not sure because Mr. Adams drove around the corner, went in the exit and found a spot without too much problem. So
I don't know if he pulled into the exact same lot though. I don't know if it was another
I
lot.
believe the video shows they located his vehicle in that lot.
Why were they lined up? Maybe they each had an appointment, maybe? I don't know. Is there anything in the record that would tell us?
There's nothing that we know of in the record. Why they were all sitting there blocking that lane of traffic.
With the sign.
With several no parking signs along the way, you can see in the video.
Because this is clearly not a situation where, I mean, we've all seen it. It's a busy roadway. Somebody can't get into a lot, so they pull their car partway in and then it backs up traffic. You know, that first car is probably arguably impeding traffic, but none of the other cars are because they're just stuck in traffic. That's not what we have here. Clearly, each one of these cars is individually parked. In one situation, it looks like there's 2 car lengths between 2 of the cars.
Yes, it's not Saturday in Ann Arbor or East Lansing, where you kind of expect that. And there was some suggestion by defense that, well, the only reason they're writing tickets here is because the supervisor lived nearby. And so I think that's why the prosecutor, that may explain why the prosecutor talked about why this is a problem. This is a problem on this street. It's a busy business. And we are deciding to take more aggressive action. But I'm happy to answer any of their questions or.
He did let all the other drivers go without giving them a ticket.
Things did change and he decided not to write the citations and go after the individual who committed a felony, yes.
They all benefited, that's right. They benefited.
Sometimes things work out that way, true.
Lucky day. I mean, the most fascinating question here isn't even before us, which is the impeding traffic statute in the Michigan Vehicle Code overly broad or vague? But that's not before us.
Well, I hope that my analysis helped in some ways to go, well, this is what the statute said. These are the definitions we have. And maybe it's not well known that if I'm sitting here idling my brake on it, and if I'm not unloading or loading somebody or repairing somebody, I'm technically parking. And maybe that's not well known, but that is the violation. That's why really people should follow instructions of officers instead of deciding that they're just going to do their own thing.
Well, the reason it's arguably overly broad, and this is probably what that White case says, is that if you were stopped behind other vehicles in traffic, you could technically be violating the statute.
Well, they indicated at a stop sign or a stoplight, I believe
that's not as good of an argument, but I think stuck in traffic, that's something we could argue about. Right. The other argument implicates other portions of the Michigan Vehicle Code, which would be traffic control devices. So that argument, it probably isn't quite as strong as you're just stuck in traffic.
Right.
Behind 5 or 6 cars, let's say, somebody turning left. But anyway, I digress. Anything else?
But that's
Instead if an officer would actually write some.
They would not, but that's not the point. The point is the statute itself overly broad, but we don't really need to look at that because it's not in front of us here today.
Well, I would kind of the general distinction, the difference is there are no parking signs along the street and those people are all waiting to go into a business. They weren't just stuck in traffic.
Those people were parked. Yeah. I mean, I know the argument that's being made here, but they were parked.
And White is different because I mean, there it says she was not parked or standing within the meaning of the ordinance prohibiting parking or standing vehicle or signs prohibiting that were installed because she was hit by a bus while stopped in the bus stop loading zone. She had her foot on the vehicle's brake and was helping her load her daughter into the vehicle. So
that somebody was getting in. So under the definition.
A very different sort of circumstance. So.
I have wondered about this very topic when I'm in my neighborhood on a 2-way street and the Amazon driver decides to just park in the road. Mm-hmm. And there's no signs around that say
No parking.
Or no standing.
Right.
The difference between the signs that say no parking versus the signs that say no stopping, standing, or parking. But anyway.
Well, thank you very much.
Thank you. Hopefully you get to go home now.
We can look ahead. It looks like you can.
I just wanted to respond briefly to the prosecutorial misconduct issue. The prosecutor said that the statements about Mr. Adams being from out of state were an attempt to explain why Mr. Adams might not have wanted a traffic ticket or why he left. Again, there's nothing in the record to suggest that that is the case of why the prosecutor stated those things. And there was no evidence that that's what Mr. Adams intended to do. So
I think what he was implying, and maybe I misunderstood him, I think he was implying that the prosecutor was trying to explain to the jury that perhaps the reason the officer didn't chase after him was that he knew he was from Minnesota and he didn't want to get into a long distance pursuit.
in my reading of the record of the prosecutor's comments, there was no insinuation that that's what the prosecutor was trying to say to the jurors.
But when do we get to the point? Because it would be easy for everybody to say, well, the prosecutor said enough to the point where the instructions to the jury could be disregarded and it affected that. I mean, what's our test? What's our standard for that? Because everybody up here, and you heard me even ask the same question in a prior case. So do we just throw it out anytime counsel says, oh, no, it was more than could be fixed by the instructions. So what's the standard there?
I mean, the standard for prosecutorial misconduct is whether the defendant is denied a fair trial. And I think you have to look at it, obviously, in the totality of the circumstances. This was a one-day trial. This all happened at once. And the prosecutor's comments were throughout the entire thing, all about completely irrelevant topics. So I think that in this case, it far meets that fair trial standard or surpasses.
And there were no objections by defense counsel. Which then goes to ineffective assistance of counsel.
Yes, which we also raised under this issue.
Then we have to look for error on the record. So
unless the court has further questions.
Questions?
I don't.
Okay, that matter is submitted and we are going to take a short break. Thank you. We will now start our 11 o'clock case call, which starts with case number 10, which is docket number 373471, Baldwin v. Williams. Good morning. Tom Chadwick for the appellant. By way of introduction, my father is a retired CPA. My brother's a high school math teacher in my hometown. And there's a reason I went to law school, is to get away from math. This is a math case.
I tell people that. I said, that's why I didn't go to medical school, because I don't do math. I went to law school instead. So I'm with you.
You are all reasonable judges. I wouldn't tell this to just any judge, but I sometimes tell clients, there's a rule about lawyers and math. Lawyers are bad at math and judges are worse. And they find that out when we get to the courtroom. If I walk in with a piece of paper and the math's all done, I've never had a lawyer or a judge question my calculations. They might say the number's too big or too small, but they let me do the math and that seems to work out better. So I thought I would make your jobs easier with my brief. I did not include a lot of calculations and amortization schedules. I just took the numbers that I thought were most salient and that you could understand the story by seeing those numbers and how they work with the application of the law here. And that is the real problem in this case, is that the district judge did not come to any conclusions. And I don't believe he applied the law. And so the basic question in any land contract is what is the original contract purchase price?
Right.
That question was never answered for us. It's not clear from the, well, I would think it's clear, but it doesn't seem to be clear from the land contract itself. You see an actual number there, 35,000, but you also see these extra words that say, pay off my mortgage plus interest. What does that mean exactly? And what did it mean to these two parties when they entered into that contract in 2013? We know what it meant to them after the contract was signed. It meant that Mr. Williams would pay $400 a month, and he faithfully did, and that was acknowledged in the record that he had paid over $56,000 in payments over the 11 years that the contract was in place. But we didn't get an answer from the district judge of almost 30 years who should know how these land contract forfeiture cases are supposed to go. We didn't get an answer from him on what the actual amount would be to pay off the land contract and receive title, which is what Mr. Williams agreed to and which is what Mr. Williams is entitled to today in 2026. He needs a deed. He's paid more than the written amount of the purchase price. And I believe if you filled in the blanks using extrinsic evidence, the judge didn't do this, but if you were to do that and reasonable amount of interest being 7% in 2013, he still would have paid it off within 10 years, and it's been more than 10 years. So that first very basic piece of information we don't have even after an entire trial with the bench trial with the district court judge.
If the district court lacks subject matter jurisdiction over this, do we just send it back?
Send it back to the district
Dismiss
court?
this, right, and dismiss it?
Problem is the timing of this. I didn't realize he lacked district or subject matter jurisdiction until my wife, who's a lawyer, told me about it. She does bankruptcy cases and she was familiar with this rule. I was not. So between the entry of the judgment and the 6-month period to cure the defect, we filed a motion asking to remove it to circuit court for lack of jurisdiction. Now, the timing seemed to be important to the circuit judge sitting in appeal on this, but I don't believe the timing is an issue.
Subject matter jurisdiction can be raised at any time.
Yes. And it was clearly raised and it was never addressed either by
Wouldn't the remedy just be an order directing that to be dismissed without prejudice, and then plaintiff could proceed however plaintiff, preferred?
Yes, I agree with that. That's what I asked for in my brief, that you dismiss the district court case. And we've already filed a quiet title action in circuit court. That judge has put that on hold until this district court matter gets resolved. That would be a great resolution. I think that would fit with what the law says that the district court judge should have done in the first place.
We understand your argument.
Thank you.
Thank you.
Good afternoon, Katie Johnson, P76708 on behalf of the Helly. I'm going to skip right to the subject matter jurisdiction question. I think that's probably the more pertinent question here. When we look at that subject matter jurisdiction question, we're looking at the allegations as pleaded in the complaint. Here, there is a defense that this case should have never been brought as a summary proceeding, because I'll admit there is no forfeiture provision in this land contract. However, the question is that jurisdictional? And that's the question that is before the court. When we look at the Summary Proceedings Act, the jurisdictional statute is in MCL 600.5704. The defense could have been raised that this is not properly before the district court in a summary proceeding, which is an election of remedies that a vendor of a land contract has, as opposed to a foreclosure election of remedies. That was never raised. It was never raised in the defendant's.
Well, where does the district court get subject matter jurisdiction in the first place?
The subject matter jurisdiction would come from the Summary Proceedings Act. Again, that particular statute.
Right.
Yep.
So if the facts of the case as alleged do not comply with the Summary Proceedings Act, then where's the subject matter jurisdiction?
I think that's where we look at then Clohest, which is the case cited by the appellant in this case, as far as what that means. That case is not a summary proceedings case. Instead, it's about jurisdiction in the district court based on the statutory amount pled. In that case, the allegations were that the amount of damages was less than the $25,000 threshold. It turns out, by consent judgment, the parties agreed to a judgment of $222,000 and some change. And the issue on appeal was, well, if that amount that is over the jurisdictional limit, should there have not been jurisdiction in the district court? And the court directs us to, again, look at the well-pled complaint. So we have to look at the complaint in this case. And again, there is no defense that was raised that there is a prerequisite that was not met to go forward with this election.
But the complaint specifically references the deed itself, right? So that means the deed itself becomes part of what's alleged in the complaint, right? And the deed itself doesn't say anything about foreclosure.
Yes, it references the land contract, and then the form of the complaint itself says that there is an ability to pursue a forfeiture action. I'm not saying that the forfeiture provision isn't in the contract. It's not. It's not. It's just a question of whether that is part of the subject matter jurisdiction, which has not been decided by this court at this point. And it is a distinction, of course, that will have to be resolved. I would like to address some of the other issues raised in this case. I know that subject matter jurisdiction piece will probably be paramount to the court's decision. But I do want to go to the contract interpretation issue. Regarding the contract interpretation issue, there's a question here. First, the court does review a contract de novo. And particularly here, I believe everyone agrees this is an ambiguous contract. And when a contract is ambiguous, as we look at the case cited again by the appellant Clapp versus United Insurance Group, the interpretation of an ambiguous contract is a question of fact, which would have to be decided by the lower court. Here, the court did make some findings. First, the court found that Ms. Baldwin was the owner of the property. The trial court also found that there had been a material breach in the contract. This was never raised as a non-payment case. Mr. Williams was continuing to pay the monthly amounts due until Ms. Baldwin brought this forfeiture action because the conditions of the property were abhorrent. And the court found that Mr. Williams had breached the contract because he had failed to keep it in good order inside and out. And there was ample testimony on the record as to what did this contract provision of the purchase price, including the balance on Chase Bank plus interest, meant. And there's evidence, of course, from Ms. Baldwin as to what that meant and the discussion she had with Mr. Williams before they even entered the contract, showing him this is the mortgage. This is what you will be paying off. This wasn't a gift. Ms. Baldwin still owes on the mortgage to the state that Mr. Williams is no longer paying despite court order, as you can see from the transcript. And more particularly, though, I think what we can look to is Mr. Williams' statement of, I understood I had to pay off the mortgage. That's in the transcript on page 100, line 5 through 8. He knew he had to pay off the mortgage. He knew this was not a gift from Ms. Baldwin in this case. And the court then found that there had been a breach, and the district court found that there was a 90-day redemption period, which presumes less than half of the purchase price had been paid. And we have testimony on the record that supports that. We have Exhibit 5, which was the Chase Bank mortgage statement at the start of the land contract, which comported with the purchase price, Chase Bank mortgage plus interest. We had the Chase Bank statement at trial, and we had the payments that had been made toward that mortgage that Ms. Baldwin testified she applied as the payments came in from Mr. Williams were paid to the mortgage. At the end of at trial, the amount on the land contract was $18,623.72, which is less than half of the purchase price that was paid. But even if the district court erred and more than half of the purchase price was paid in this case, the redemption period would be 6 months. And the redemption in this case, again, was never to pay up the land contract. There were no missed payments. Mr. Williams continued to pay. It was to clean up the property. And we have been back in district court as in part of the record because that issue has not yet been cured. There are continued letters from the township to Ms. Baldwin and fines being imposed on her to clean up this property that has not been cleaned up. So I believe, Your Honors, the question of if this is there's one question is one, does this contract provision is of the purchase price show a meeting of the minds as to what was the purchase price? If there's no meeting of the minds based on contract interpretation, there is no land contract. And yes, again, this case would be dismissed and Ms. Baldwin can go ahead and file an eviction with a 30-day notice. And that is a question that I believe the court can review with on de novo. If instead this is a question of an ambiguous contract and the interpretation of that contract, that's a question of fact that would have to be remanded to the district court judge in this case. There was a third point raised I do briefly want to touch on, which is that the district court erred in failing to remove the counterclaims. Now, there's two separate issues between the counterclaims that were raised and which court had subject matter jurisdiction. And then this question of, was this forfeiture properly pled under the Clohest standards? Regarding those counterclaims as appellant's counsel has stated, are in front of the circuit court right now. They have been filed in front of the circuit court. Appellant asked for those claims or raised those claims for the first time March 14th, 2024 at a status conference, at which point the court had noted and is in the court notes as presented that the court expected a motion for removal of those claims. The parties came back before the court before trial for a status conference on April 9th. The appellant defendant asked orally again for those claims to be removed. And the judge stated, file a motion today to remove those claims. It was never done. The motion wasn't filed until well after the trial and the judgment was entered in this case. The district court does have discretion under the court rules MCR 4.002 to impose such conditions to require a litigant to file a motion for removal so that it can properly be responded to. It never happened. Mr. Williams sat on his rights and didn't raise that issue again until well after the judgment was entered. In that case, because he has sat on his rights, that issue was waived. Just like the issue was waived of whether or not the forfeiture provision was in the land contract. It was never raised. And as we cited, the Walters versus Nattle case, I'll use in closing unless there's further questions. The reason for this raising and preserving of issues is we are limiting on appellate review to those issues raised and argued in the trial court and holding all other issues waived. Appellate courts require litigants to raise and frame their arguments at the time when their opponents may respond to them factually. This practice also avoids the untenable result of permitting an unsuccessful litigant, here Mr. Williams, to prevail and avoid its tactical decision that proved unsuccessful. Mr. Williams submitted himself to jurisdiction in this forfeiture. We had a full trial where evidence was presented on both sides, and he did not prevail. He already appealed this to the circuit court in Ionia County, which denied his appeal. This is on application for leave to appeal, which has been granted. And we would ask at this time that the court determine that the issue of whether or not there was a forfeiture provision in the land contract is not an issue of subject matter jurisdiction because that was well pleaded in the complaint. It was a defense that could have been raised and was not. And I would ask if the court has any other questions.
It seems like did anybody inform the district court that they should have interpreted the land contract, should have determined how much was owed, should have done all those things, or did they just not want to push it?
The wording of, when you look at the transcript, if I may grab my transcript.
Yeah, absolutely.
This is on pages 131 to 133 of the transcript. The district court kind of mulls over this issue in his opinion, or the court's opinion, and essentially says, I don't know if I can enforce that, is the language used. I don't know if I can enforce this contract provision, which if it's true and there is no meeting of the minds and there is no land contract, again, the result would be that this case be dismissed and then that Ms. Baldwin can then pursue an eviction with a 30 days notice because she is the one with title to this property and Mr. Williams wouldn't have that option. So if the question I think was, did anyone address this to the district court? This was what we asked the district court to conclude because one of the necessary findings for that redemption period is whether or not 50% of the land contract balance has been paid. And he determined that he could not determine that based on the language of the land contract.
But even though that he showed the evidence of the fact that he'd been paying and paid what, $56,000? Well, he or the people who were living with him, who he made pay on his behalf. And even despite that information, the district court wouldn't say, okay, they've already paid $56,000, but here's how much is owed because it was a variable interest mortgage.
Yes, it was a variable interest mortgage. And so, and I would just note to Exhibit A of appellant's brief is not in the record. That is something that was created for appeal purposes. So we really do have to look at the record when we look at what evidence was presented to show what was paid. I don't believe that when you look at the record, Mr. Williams really presented any evidence. There's no receipts. This is a land contract between family members. There's zero receipts, very vague evidence from Mr. Williams as to what and when he paid versus what Ms. Baldwin testified as to when I received the payments, I applied it to the mortgage. Here's the mortgage statement at the beginning of the land contract, the statement showing all the payments that have been made on this land or toward the mortgage, and then what is the current balance. This was not a gift. No one, when Mr. Chadwick's point is, well, we paid more, of course, than what was owed as the original purchase price. That's true in any case when you have a mortgage. There's interest. There was interest in this land contract and it's expressly stated on that. But to your honor's point, I do believe there should have been a determination specifically of whether 50% or not of that purchase price has been paid. But that leads to the question of, is this moot? It's well past 6 months since this court made the determination that there has been a breach of the contract by Mr. Williams, the breach being the property not cleaned up. We'd happily have this remanded to see if the property is cleaned up. And I think Mr. Williams understands that it is not cleaned up. It has gotten worse in that time period.
Questions?
No.
Thank you. If I heard Ms. Johnson right, the first issue was that the contract was breached because Mr. Williams failed to keep it in good order. That was a provision of the contract. However, I cited Guilford versus Watkins on page 11 in my brief. Guilford versus Watkins stands for the principle that once the purchase price of the land is paid, the vendee is entitled to conveyance of legal title. So once he paid it off, he didn't have any more obligation to keep it in good order. That part of the contract would have been void. The only problem is he could not prove, or the judge did not make a finding whether or not he paid it off, and we did not have a number for what he needed to pay to cure that defect. So the issue of whether he kept it in good order is not,
Isn't it fair to say, though, that whatever that number is, it would have had to have implicated completely paying off the mortgage on the property?
it would have. The burden of proof is on the plaintiff to prove that the amount was certain and that it has not been paid, but the plaintiff wasn't able to prove that. There was evidence at the trial that some of the payments to the plaintiff were not applied to the mortgage. Biggest one being that $2,000 down payment, never applied to the mortgage. So we don't know what the mortgage should have been if those payments had been properly applied. And it isn't Mr. Williams' burden to prove that he paid off the mortgage. Obviously, he didn't pay off the mortgage or would have paid off the mortgage if they'd been properly applied. It's a burden on the plaintiff to prove that he failed to pay a certain amount that was clear from the contract.
Of course, from a practical standpoint, and this is not before us today, but from a practical standpoint, if even if the court determined that he had paid everything he was obligated to pay under the contract, you'd still have to pay that mortgage, or there'd be another eviction sometime down the road, done by the lien holder.
That would be an issue for him to resolve with Ms. Baldwin.
Or the lien holder.
Well,
I mean, they're going to have a lien on that property unless that money gets paid off, regardless of what happens here.
I presume he'd want to keep his house.
Yeah.
The second issue was about the counterclaims and not being timely filed. This is a summary proceedings case, so the answer is not due under the normal time limits, but a counterclaim and an answer were filed in this case. And it was pointed out to the court, and it was in the record that the judge was aware that these equitable claims were going to be claimed in the counterclaim, and in the motion to remove it, the trial court has an obligation to remove the case to the court with proper jurisdiction on its own initiative, and that wasn't done here. The fact is, after those claims are brought to the judge, he ruled against them anyway. And so I don't know, it's not surprising he didn't bring it up on his own initiative, but that should have been done, and that would have been proper in this case. There's a third issue, I don't remember it, but if you have questions, I'd be happy to answer those.
I have none. Questions?
Thank you.
Thank you. That case is submitted. We're moving on to our next case on the docket, which is number 11, docket number 377110, Francesa versus Rep.
Good afternoon, Your Honors. Sam Vitale on behalf of the appellant cross appellee, Christina DeJoy, formerly Christina Rep. Your Honor, we're here on a custody matter involving the parties' minor child, Nico, who at the time of trial was 11 months old, is now 2. There are 3 issues I'd bring before the court. The first error that we're claiming is that the court made express finding that the established custodial environment was exclusive with mother, and that father failed to show by clear and convincing evidence that a change would be in minor child's best interests. But then the court, despite these findings, proceeded to do just that and enter an order that modified the established custodial environment. Secondly, we're arguing that the trial court failed to address the statutory parenting time factors, ignored uncontroverted expert testimony in reaching its parenting time decision. And finally, that the trial court failed to make findings or consider the best interests of the minor child in regard to changing the child's surname. Again, with the parties had a 2-day trial, and following that trial, the trial court correctly found the established custodial environment was exclusively with mother. Minor child had never been in the care of father, And there was little evidence, the court found, to show that there was any meaningful bond between the father and the minor child. Now, under MCL 722.27, the trial court, because of these findings, was prohibited from changing Nico's established custodial environment.
Could you use his initials, please?
I'm sorry, yes.
For the child.
The minor child, yes, I will.
Thank you.
Prohibited from changing the minor child's established custodial environment, absent clear and convincing evidence that that a change would be in the child's best interests. Not only did the trial court itself expressly found that he did not, that father failed to meet that burden. But nonetheless, the court entered an order requiring taking father from 0 parenting time, 0 contact with the child, to 3 weeks of video, then 8 6-hour visits, and then after only 2 months, 8 weekend unsupervised overnights, and after 4 months, 1 week per month unsupervised parenting time with father. So he went from 0 to 90 overnights in just 4 months. Now, this court has consistently found that a significant modification can change the established custodial environment. It's not a strict mathematical formula, but cases with less significant changes in overnights have been found to constitute a change in the established custodial environment. Opposing counsels raised the issue in Lieberman, alleging that Lieberman creates a rule that the established custodial environment can only be changed where a parent shifts from the so-called minority parents or minority custodial parent to the majority custodial parent. That's not the case, and that's not what Lieberman stands for. It looks at whether the court's order will change who the child looks to for guidance, discipline, and the necessities of life and parental comfort. Prior to the court's order, that rested solely with mother, and mother then went from being the sole caregiver to only 3 weeks per month, with father exercising an entire week per month of parent time.
Gradually with the steps that you mentioned, right?
Yes, somewhat gradually, but really we're talking about, 8 visits until he gets there. I mean, it's alternating weekends. It starts off with, a 2 days of 5 hours or so, and then 1 overnight per month, 8 times, and then he's to 3 weeks or to a week every month.
Okay, so is the point that it should have taken longer?
Well, the point is that based on the trial court's findings, that he should have entered an order that maintained the current established custodial environment. Now, that's not saying that at some point that can't be changed.
So then what would you say, what parenting time would he get? 0?
No, but he could certainly, I mean, I think the third phase of this where he's at, alternating weekends, he has an overnight, he gets to establish a bond, and then he can come to the court and say, look, established custodial environment is still with mom, but look at what I've done, look at the parenting time I've exercised. At this point, I can show that it's in the best interest of the minor child to modify the established custodial environment and award me more parenting time.
Did the mom though, once the dad had started the parenting time, did she object at the trial court that, look, the child still isn't having a good transition? For example, the child is not sleeping when they come home from dad. Dad isn't spending time with dad's dropping the child off for the unsupervised visits with a relative. Anything like that? Would that ever attempted?
Yes, absolutely. Yes.
Okay,
Since the order's been entered and
Okay.
this has been pending.
And the court just said, no, forget it. We're sticking with the order.
This is, as far as I know, that's obviously was not an issue in trial, but post judgment, my client has raised that there have been significant issues with the parenting time that's being exercised. And that, as far as I know, that's just continued along the schedule that the court has set.
So the trial court changed nothing about the schedule
Correct.
after having your client raise those issues.
Correct. Secondly, as I referenced, that MCL 722.27A provides factors to determine the frequency, duration, and type of parenting time. I acknowledge the factors are permissive, but the court in Shade v. Wright indicated that findings should be made on contested issues, of which there were several in this case. At the time of trial, the minor child was still nursing. The trial court's order requires significant travel burden on the minor child. Essentially requires him to wake up at 4 a.m. on Saturday, travel 6 hours to Illinois, stay at exercise parenting time, stay at a hotel, go back to parenting time the next day, and arrive back home at 11 p.m. or later. That's under just the third stage. But the travel obligations were significant on the minor child. And finally, on the final contested issue would be the father's ability to exercise parenting time. As the trial court itself found, the father seemed more concerned with gaining a leg up in the litigation instead of attempting to exercise parenting time. He refused to take any parenting time other than this, all or nothing approach. I want the child delivered to me in Texas, or, and if that's not available, I'm not going to meet him. He had, at the time of trial, never even referred to the minor child by the child's name. Additionally, the trial court disregarded unrebutted expert testimony that specifically addressed the issue of a more gradual approach where, initial contact would take place with the minor child and his primary caregiver present, and that he could develop a bond with the father before father's parenting time increased. The last issue is the issue of the change in surname, which under Michigan law required that the court make findings as to whether a change in the surname was in the best interest of the minor child. The sole focus of the trial court's decision was mother's motivations for changing or for giving the minor child her own maiden name, which the trial court deemed to be an act of vengeance. There's no evidence of this beyond father's speculation. Mother denied that she did so out of vengeance, and she was not denied being upset by father's request for a paternity test. The fact of the matter is that father left while mother was pregnant, made no attempt to contact mother until after the child was born.
Mother left Texas.
Mother left Texas
Michigan.
after father moved out of the home. And
Got it.
stopped
Sorry.
contacting.
Thank you. I understand.
Thank you. And so giving the child her maiden name was consistent with the involvement she believed defendant was to have at that time, which was essentially no involvement. Your Honor, the child's home physically, emotionally, psychologically is with mother. Father failed to prove that changing the environment serves the minor child's best interests. The court here made all the right findings and then did something else. That's a different situation than I think most of the cases that are presented to this court are, where the court has either, failed to make specific findings or not held the hearing in a timely manner. Here, the court checks the boxes, and if you're reading the opinion, it seems, okay, there's an established custodial environment with mother. Father has failed to meet his burden of clear and convincing evidence. And then with seemingly no reference to his findings, the trial court just fashioned his own remedy. And so these safeguards exist for a reason, and they should have been followed when creating that decision.
So what you're saying is that the court erred by reuniting the father and the minor child too quickly.
Yeah, so I believe that the change in parenting time that under the court's order was so substantial that it modified the established custodial environment.
No, I would disagree with you on that, because she moved, they're states apart, right?
Mm-hmm.
And so this is not, you can do like Wednesday evening, Saturday evening, those sorts of things. And the statute also says that it's in the child's best interest to have contact with both parents. So You can't say that we're going to give him parenting time when he lives in Texas and we're going to make it in Illinois where his family lives, right? And say that's changing the ECE. She still has the ECE. She still has it. And the fact that he has parenting time, I don't really see persuasive any cases that you cited with respect to the fact that just by giving him this graduated amount of time, where she's still getting the majority of the time, even after everything's done, does that establish custodial environment?
Well,
Bless you.
so Your Honor, I would disagree. I think that if you just look at, there's the first three phases of this parenting time schedule, right? There's the first is video chats, and then there's
She still has the ECE.
She still has the ECE, 2 days per week,
She still has the ECE.
and then one overnight on alternating weekends.
She still has the ECE.
And I would agree with that, Your Honor. But the problem, I think, is the jump from that third schedule to the 1 week every month.
But then it addresses your complaint or your client's complaint that this is too much traveling for the child. Whereas if you do the week, then there's no traveling, there's no going back and forth. So you're only looking at it in amount of time. And I don't see any cases that I'm aware of, and you haven't cited any, that says merely by increasing the amount of time that you go from 0 to this changes the established custodial environment. And did you have any?
Well, I believe that both the Lieberman case and apologies.
I didn't think Lieberman went for 0 to a graduated schedule.
It did not, but it was a loss of 85 parenting overnights in a year constituted a change in the established custodial environment. And my clients lost 90.
But that was a completely different case. And Lieberman, he's got 0. So she's obviously going to lose something. And how you go from 0 to a little bit video, that's a reasonable. Then you go to once, right? And then you go to the weekend sort of thing. And then beyond that, again, it's directly addressing the difficulty of traveling. And this is a minor child who doesn't go to school, and it seems to be perfectly reasonable. So again, I am just going to disagree with you that merely because he has a week of parenting time once a month changes the established custodial environment.
My response to that would be, I think we're on the same page up until that fourth factor.
But again, so what did your client think we should have done? Okay, do half a week for a couple of weeks, and then do 5 days for a couple of weeks, and then do 7 days for a couple of weeks, because you would have ended up at the same resolution once you hit 3 days once a week.
I think what the trial court's order does is take a schedule, a graduated schedule, and then at some point make a jump, which requires a evidentiary hearing and findings on the best interest factors. And the court can't make those findings until those first three factors, those first three stages are done. What the court should be doing is, okay, if you want to, you're going to grant him some parenting time. We're not going to mess with the established custodial environment, but we'll grant you parenting time. And then at a certain time, whether it be 3 months, 4 months, whatever this, the proposed plan is, at that time, if the court wants to go more, then I think the court has to find that there's, it's in the best interest by clear and convincing evidence to change the established custodial environment.
But that's where I disagree with you, because merely by increasing his parenting time is not giving the dad an established custodial environment or changing the established custodial environment. That's the same thing. I have difficulty with saying, well, when the dad's with him, he has legal custody. I think that's just out and out wrong. It's just out and out wrong, because that would be anybody who has week on, week off custody. You could never have sole legal custody with one of the parents. It doesn't work that way. You only give sole legal custody if the parents can't agree on the important decisions regarding the child's life. So they can't talk to each other whether the child should have surgery, whether the child should be baptized, whether the child should be circumcised, all those important, the meat and potatoes of parenting, right? So, but there's nothing in the law that says once you finally get to a certain point, and I'm trying to figure out what that tipping point is with you, and it seems to be more than weekends, that you have to have a hearing and make a whole different determination. And that is because I disagree with your basic point that once you go from weekends to weeks, it changes the established custodial environment. And like I said, Lieberman is factually distinct, and I just don't think it applies here, but that's just me.
Understood, Your Honor. I would just say that I think the week-long time being apart from mother is going to fundamentally change who the child looks to for parental guidance, you know, necessities of life. Whereas a weekend
Why?
parenting time.
Why though? I mean, the child still has contact with mom when they're with the dad for the week, right? They
Right.
still have video conferences and talk to him on the phone and all the rest of that. So I don't see why all of a sudden she gives up the ECE.
I'm not saying she gives up the ECE. I'm saying one is going to be established with father where it didn't exist before.
The ECE happens over an appreciable period of time. That's in the statute, an appreciable period of time that the child looks primarily to one parent or the other parent for the necessities of life, for care, for comfort, all the rest of those sorts of things. And the mere fact that the child's going to initiate that with dad and begin that with dad when the weeks start doesn't change the fact that the child has it with mom.
I would agree that my argument is not that it's eliminating the established custodial environment with mom. I'm saying that, you know, if the trial court finds that the current established custodial environment is with mom exclusively.
Then you're saying
And
that
then-
dad can never have more than just weekends.
No, I'm not saying that. I'm saying that dad needs to at some point show that by clear and convincing evidence that it's in the child's best interest that he does have that.
But he doesn't ask for the established custodial environment. He just wants parenting time.
Right, but parenting time a change in parenting time can change the established custodial.
And I guess that's the point at which we differ, because I don't believe the parenting time that the trial court had in place changes the established custodial environment or gives it to dad and equally with mom. I just
Understood.
don't see it.
Understood. I have nothing further unless there's any other questions. I do have response to the cross appeal. Should I save that for rebuttal? Or would you like me to?
Yeah, why
address that?
don't you go ahead and respond to the cross appeal?
Okay. Just very briefly.
You've got plenty of time, by the way.
Thank you. Just very briefly, you know, father seeks joint legal custody at all times, a progressive schedule reaching 50-50 physical custody, and a reallocation of travel costs. Each of these requests require that he demonstrate that the trial court errs in ways that preponderate against its findings, a burden he has not met. On joint legal custody, the trial court found that these parent parties have a problem communicating with each other, that concerns exist as to whether they can be flexible with each other. And the record supports the trial court's conclusion that joint legal custody is not realistically feasible given the distance between the parties and their inability to cooperate. I believe both parties testified that they wouldn't be able to cooperate regarding major decisions. If anything, the trial court erred in granting father any legal custody, given its own finding that father failed to establish by clear and convincing evidence that a modification was in Nico's best interests. Yes.
When the party that custody, but nobody says that party has sold the book custody, can you do that?
I've never seen that, Your Honor. My understanding is that you can grant sole legal custody to one party or joint legal custody to both parties, but I've not seen it on an alternating basis. I understand possibly the concern that when, you know, if the child is exercising parenting time in a different state and he's with father is going to need to possibly be able to make, you know, emergency medical decisions,
Right.
but I don't believe that necessarily requires a finding that he had sole legal custody at that time. I think it would have been frankly more appropriate for my client to maintain sole legal custody, given that she's the primary caregiver, and that, you know, if there are emergency issues that are, you know, occur while the minor child is in father's care, that those be addressed at that time.
Could we vacate that part of the court's order? Can there only be at this point one
I believe that would be
legal custody,
necessary.
given what you've just told us about why there should be no custody?
I believe so, Your Honor, yes. As to physical custody, father concedes that the established custodial environment was with mother and acknowledges the clear and convincing evidence burden. He has not met it. Trial court found so, and the record supports that finding. There's no basis for an award of 50-50 custody, physical custody. And as to travel costs, the allegation of those costs, the burden, the burden of the travel costs is squarely within the trial court's discretion. Father lives in Texas. Mother and the minor child have resided in Michigan. The trial court placed the transportation burden on father, but I think the more burdensome travel impact is truly on the minor child, who is the one who is, most primarily affected by that. So I would argue, if anything, the burden on the child should be reduced, not the burden on the father. That's all I have on that, Your Honor.
Thank you.
Reserve any time for rebuttal.
You've got about 7.5 minutes for rebuttal if you choose to use it.
Thank you.
Too late in the afternoon, Your Honors. Kevin Gentry on behalf of the appellee. I've occasionally seen children treated as a zero-sum game, but I've never heard that literally before. But that's what they're arguing. He wasn't kidding. Mom believes the child should have zero time with dad. And that's really what they're arguing here, is that if there's established custodial with mom and there's no time with dad, there never can be time with dad. Now, he's coaching it, saying, well, there can be weekends, but then what happens? Shader Vodvarka. You can't just go back and visit. Now the dad's got to show a change in the child's life. We don't want Vodvarka changes to happen in children's lives. They're usually bad. We want to have, as the statute says, parenting time with both parents. That's why he's wrong. There's a few other things going on here, but I think Judge Feeney said it a lot better than I could, which doesn't surprise me. So I will just let that go because I think that Judge Feeney made most of the points I made. I've got lots of little scratches here. But the biggest thing is, under their view, it just can't ever change. I mean, she managed, and we would say not in good faith, to get the child away from dad and move across the country. And so hands up, touchdown, and it's over? No, the child deserves better than that by a lot. Now, a couple other questions that came up with the court, and I'll go to joint legal custody because, Your Honors, I've never seen that either. But I understand there's a real problem here. The kid's in Texas and falls off the place when, God forbid. Could we see in this situation, if mom had sole legal custody, her refusing to go to the hospital with a broken arm until such time as she got there? I don't know. I mean, I hope not, but there's all sorts of things. If this court's inclined to find that that's illegal, and I think that there could be a basis for that. I'm not going to say I've ever seen that before, and I'm not sure it's an option under statutes.
Mr. Gentry, frankly, I've been, and I know Judge Keenan has been in family law a lot longer. I've only been dabbling in it for the last 8 years during my time here, and I've never seen it.
27 years for me.
Somebody has to have legal custody, right? You start with the joint, and then here they can't, which is unfortunate because, as you point out, a child, it's presumed in the law that a child benefits from having a relationship with both parents, not just one parent. So, but here they can't do that. So we have to pick someone to.
What I would suggest, Your Honors, and this may be an argument for trial court, but having done this for a long time and having kids in a broken household, it might be that one party has joint legal custody and the other party has a durable power of attorney for healthcare when their child's in their care. Something as simple as that could resolve this problem. And it may be that that's going to be something that has to be argued at the trial court. It may be something we're suggesting, but I think that the trial court recognized the real problem here, which is the kids got to get medical care when they're in care of whoever isn't the joint legal custodian. And I think that's it. I wonder on this record whether there was a 722-26A1B finding that the parents couldn't get along on issues regarding the child. I don't know that there is, because I don't know there's ever been an opportunity. I mean, yeah, they hate each other. We're sure about that. But I don't know that we've ever had any findings that they could
At some point, they have to put the best interests of
Oh,
the
absolutely.
child at the forefront. So,
And what I'm saying is they haven't not, because my client's never been given the opportunity. There hasn't been a daily issue here where this court found appropriately in daily that the two parties were at loggerheads over everything regarding the kids. These parties are definitely at loggerheads, but we haven't had any issue where the child has been twisted into a pretzel by my client. And I think that's an important finding that wasn't made here, that preponderates in the idea that they should have joint legal custody until such time as one of them proves they can't, which may happen or may not on these facts. We don't know. We hope not.
Is there a reason why your client hasn't moved closer? I mean, there were allegations, as I recall, that he comes to Michigan, he doesn't ask to see the child. He's in Illinois, doesn't seem to see the child, doesn't make that extra trip up to Berrien County. And parents need to do everything that they can, right? We don't want people to move more than 100 miles away from each other. Now it's as the crow flies. It used to be by MapQuest. I don't agree with the crow flying because kids are not crows. So I don't understand that part of it, that, you know, that would probably take care of a lot of the pressure and the stress on the child for all this traveling.
It would, Your Honor, but it would also uproot him from his job and put him somewhere he's never been.
I thought he wasn't very happy with his job and it wasn't very good.
It's not a great job. It's what he does. He might be able to find one here. I don't know. The reality is this is a Texas child. This was a Texas family until mom decided to move back with her parents when she got pregnant and all this started getting bad. And we could argue about why it got bad, but that's not really productive. I think that, you know, it's asking an awful lot, and kids do ask an awful lot of him to move and uproot his life because she chose to move in with her family. I don't know. This might be something where he might move to Illinois and we might end up with a lot shorter trips across the country for the child, and that would be great. His family's in Illinois. I could see that being a reasonable decision for my client to make, and I would certainly suggest that, because the reality is lawn trips do suck for kids.
Well, it's going to get only worse when the child becomes school age. Right.
In reality, Your Honors, looking at this, and this was something I almost raised but didn't because it's too far down the road. The county long distance standardized plan. Well, A, that scares me, and B, kids aren't standardized. So I think that that's probably going to be a problem. I did not feel it appropriate to appeal that here because we don't have facts and stuff like that. And because if I'm wrong about that, it'll appear soon enough and we'll have a case before the court. But you're right. It's going to be harder as the child gets older and goes to school, and the standardized long distance parenting plan probably isn't going to cut it for this or any other child.
So I'm guessing that's summers with one, school year with the other.
Pretty close, alternating other weeks.
Yep.
Yeah.
Yeah. Which makes
Which
it
is
difficult.
not great for anybody.
Nope.
No, I very much agree with that, Your Honor, and I hope we could find a better decision on this. I think the other thing that I wanted to address is the child's name. Your Honor,
This order was entered in 2025. Why in 2025, when a child has a name, do we assume he should have his father's name instead of his mother's name?
I can say two reasons, Your Honor. One, the child's this big and doesn't know. And the other one, probably more importantly, is that the parties were married at the time. And probably even more importantly for this court, the standard is abuse of discretion. This is a decision that could have gone either way. As this court's case law says, when a decision could go legitimately either way, it's not an abuse of discretion. It's what we got the trial court there to put eyeballs on the people for. And as to the best interest findings.
Mr. Gentry, doesn't the court have to go through the factors?
Yeah, and I would say from pages 5 to 10 of his opinion, he did. Does he have to go through all 13 best interest factors again? When he talks about, okay, the permanence. Yeah, I talked about it over here. Now I got to talk about it over here because I'm doing the name change. I think he did, Your Honor. I think he made an overarching best interest set of factors and then made a determination based on the best interest for that name. Was there another concern as well? Absolutely.
But I think it's a whole different way to look at best interest when you're talking about the name. I mean, because it has to be from the position of the child. Like, the 100-mile rule, it's always from the position of the child, not the position of the parents. And any evaluation, which he did, I think, which was very cursory, was based upon what the court believed or perceived was the reason for the mom doing it this way versus another way. As opposed to looking at, okay, what's going to happen then with the child when the child is, at school and friends and this and that. That to me is doing the best interest, analysis on the name change specifically, not on the custody.
I'm not great at math, but I'm losing this issue 3-0. And so I think I should probably say something.
I was just about to say it's going to be a real pain when he goes to get his passport.
No, this has got to be a remand for findings. I don't think this court's in a position to say the trial court abused its discretion by changing the name.
Earlier, you heard my viewpoint, which is we are not a fact finding.
Exactly. This is a remand for best interest findings, and let the chips fall where they may. And I think that's probably the only remedy that should be done here. Because if there are going to be findings made on this with these parties, there's going to be two different versions, syncope, where somebody's going to have to make some credibility determinations, and that's them, not us.
That's not us.
And with that, your honors, if there's no other questions, I'll sit down.
What?
Thank you, your honors.
Thank you. By the way, I apologize for saying your client's wrong name when or surname when I called the case.
That's quite all right. So just very briefly, I wanted to clarify a few things. Both counsel during argument as well as the brief repeatedly accuses the mother of not wanting father to have any relationship. The testimony at trial is directly contradictory to that. She did testify, and the judge, the trial judge, did find that mother did express that she wanted the minor child to have a relationship with father. I'd also clarify that the mother did not.
Whether the court found that credible or not is a different question, right?
Sure. I believe the court did reflect that both parties had demonstrated some questionable judgment on that factor. But you have to talk the talk before you can walk the walk. I think she did she did express that she did want the minor child to have that relationship, and I do think that was reflected in the court's findings.
Okay.
Also, just to clarify that mother did not ever take the child from Texas. The minor child was born here. She was in Texas, pregnant and alone. She had no family, no friends there. After the defendant had vacated the home, and so she found a job in Michigan and moved back here to live with her parents, and that's where the minor child was born. So this is not a case where she absconded from Texas with the child. I believe the original reason they moved to Texas was for defendant's law enforcement job. He no longer had that job. At the time she became pregnant, he was working as a firearms instructor. This is not, a job he would not be able to get elsewhere in the country. And lastly, just to address the long distance parenting time plan that was referenced by brother counsel, that stage of parenting time is to be implemented when the child turns 4. And so, I believe that kind of goes back to the point that we were discussing earlier, which is, at what point is the court able to predict the future and put in place a parenting time schedule that is going to significantly change the child's day-to-day life without holding a hearing? Is it just because he held this hearing when the child is 11 months old? Can the trial court then say, and when he's 4, we're going to expand it even further to this? Because to me, the issues of whether that change is in the child's best interests are going to be very different then than it is going to be when the child is 11 months old.
No, I think that absolutely you could ask for a hearing, because that's a significant change. That's even under Shade versus Wright, that's still a significant change. So
Just for example, I guess who would be requesting that hearing? Because under the
Either
court's
parent.
order, it's changing automatically.
under the court's order, when the kid turns 4, it's changing automatically?
When the court turns 4, he is supposed to go to the long distance parenting time plan.
Okay, and was that one of the things that you brought up in your appeal?
Yes, it's in the order itself.
No. Did you raise that as an issue in your issues presented? Because I didn't remember. Unsupervised overnight time, legal error and frequency, duration, and type of parenting time to defendant. So it was under that, under your second argument?
Correct, yes. So we're essentially appealing the entire graduated parenting time schedule.
What's it going to be under that plan?
I believe it's summers with one parent and then school year and with the other with the vacations.
And how many overnights is it?
I don't have that number specifically. The Berrien County plan.
What'd you say about vacations? They rotate?
I believe it's like, half of Christmas break and then I believe the summer parent would get the spring break and winter break.
Yeah, and the other parent gets school year, the other one gets the summer and then
Summer.
they get time.
Right, yes.
Do they still alternate birthdays and Christmas?
I believe so. I'm having trouble distinguishing between all the counties are a little bit different, but I believe Berrien County's done.
Yeah, well, then they have Father's Day always to dad, Mother's Day always to mom.
Right.
Birthdays and things like that, so, all right. So you're asking whether or not there should be a hearing before the 4-year-old parenting time goes into effect.
Right, I'm saying that the
This order changed the custodial environment because it included that term. Is that what you're saying?
right, and I mean, I would argue the term before that as well. I understand that, Judge Feeney feels differently, but at the very least, I do think that at a certain point, I guess what I'm saying is that same issue to me exists when the court is trying to predict what is going to be in the best interests of the minor child in the future with a pre-planned change.
And I think that's the problem. That's the real problem
Mhm.
is because you can't know. I had a crystal ball that was in the shop for 22 years
Mhm.
and nobody has a real good one when they're
Right.
sitting on these.
Right.
And I agree with you on that point that you can't predict what's going to happen once this child turns 4.
Mhm.
They could be completely different. Mr. Gentry's client could move to, Alaska, could move to Illinois, could move to Michigan.
Right.
And that's going to make everything much, much different. So, okay.
I have nothing further, Your Honor, unless there's any specific question.
Any questions? All right, you saved 30 seconds.
Right, perfect. Thank you very much.
Thanks for finishing early. Okay, that case is submitted. Have a good day, gentlemen. Calling case number 12 on the docket, which is docket number 374000, People v. Warren.
Good morning, or good afternoon, excuse me. Good afternoon, Your Honors.
Aren't you glad you came?
Yes, I was going to say it's been a very interesting morning for me. I'm just glad my kids are grown. And I'm still married to their mother.
Thank you for that.
Yes.
After every motion day, I would go home and thank my husband for continuing to be married to me. So, yeah.
We occasionally joke about it. We could never get divorced because we couldn't decide who was going to have to take the kids and who was going to get the junk.
Yeah, same here. Same
So
here.
it was just
Yeah.
easier to stay married.
Mhm.
So I don't want to belabor and consume a lot of the court's time. I appreciate you giving me the opportunity to appear this morning. And I'm going to kind of back into the issues in the brief that we submitted. I would first indicate that I'm aware on issue 4 that the only error that really remains is that the SIR was incorrectly scored. I contend that, and I believe the government has conceded error on that, that OV1 should have been scored at 0 points. As far as the second.
What can we do about that?
And this is just based on a lot of experience with doing criminal work. The SIR in the government's and MDOC's database is going to remain the same. If Ms. Warren ever encounters some type of
Issue,
thank you. It's going to follow her because it's not unusual to have a SIR or a
correct
PSI.
the SIR and have it transmitted to the Department of Corrections.
Yes, I think that would be appropriate and would afford her the remedy that she's probably entitled to.
All right.
As far as issue, I'm going to now jump to, the guideline scoring, I've already addressed OV1 and the prosecution has conceded that.
Right.
With respect to the insufficiency of the evidence, our issue 1, this truly was a fact-driven issue, and the trial was fact-issue. I have no doubt that the panel has read my brief and has looked at the transcript, and I believe there may have been a video.
Well, but where is the body cam? I didn't find it. Did you submit the body cam footage?
I did not. The prosecution, it was in her possession.
But I thought that both parties are supposed to submit the evidence to this court.
I'll be very honest with you, Your Honor. I don't remember if it was submitted or we had requested I can't tell you that. I don't know.
Okay.
I believe the court may have corresponded indicating we'd like to see the body cam because it's been raised. And I believe, and I'm dealing from recollection here, that I may have asked Marion County to forward it to the court.
Well, our court rule is 7210C, and it says within 21 days after the claim of appeal is filed, a party possessing any exhibits offered in evidence, whether admitted or not, must file them with the trial court or the tribunal clerk unless by stipulation of the parties or order of the trial court or tribunal that they are not to be sent. And then it goes on from there. But I know that that's not a rule that's complied with. So if you could make that request and get it to us, I think that might be helpful to us because there are some things here that are in dispute. And so to that point, I'm talking about the issue of how the chief of police got into the house. The door was open, right?
That was what the testimony revealed, yes.
Okay.
Or reflected, excuse me.
Yeah, and he had an active arrest warrant.
Yes.
Right.
According to his testimony as well, yes.
So the statute says when a peace officer, which he is, when making an arrest with a warrant, or when making a felony arrest without, but he was there on the warrant, may break open an inner or outer door of a building in which the person to be arrested is located or is reasonably believed to be located. Well, he knew that she was in there. After announcing his or her purpose, he or she is refused admittance. So he comes in and she goes, he's saying, I'm there to tell her, but she's taken off toward the back of the house.
Sure. And this is where I believe it gets factually somewhat convoluted because the question becomes, was he there to arrest her or was he there to lend assistance to
respond to the person that was evicting her?
And he testified that he had already acquired all the necessary information to establish, at least in his own mind, that there was an arrest warrant and he set out for that purpose.
Can I ask you a different question? At that point, is she trespassing? Does she even have standing to object to him coming into the place that she's being evicted from when she's been told you're being evicted? And she says, no, I'm not.
Well, and there again, and I'm not an expert in mobile home or prefab housing eviction, but I will say this.
So
Okay, but I will say this, based on my limited knowledge of it, that she rented the space where the mobile home sat. So the question becomes, was he evicting her from that space or from the mobile home itself? And I would submit that if it was from the space, then she continued a possessory interest in the mobile home that she could consider somebody trespassers within her home.
Meaning she could have pulled it off of the space, taken it down the road.
Yes.
But that's not what she did. It's a really good answer, by the way, but my answer would have been the prosecution never raised that.
Well, okay, I want to dance around it a little bit, but yes, I understand that. And the other part of this case that of course is somewhat frustrating is that with a limited incarceration that Judge Jansa gave her, all of the, I've explained to my client, she can't get the time back that she served in jail.
that's correct.
And she's aware of that, but she feels that she was wrongfully convicted. And so we continue to pursue issues 1 and 2. I do want to just highlight very briefly my contention with issue 2 as far as the jury instructions. I believe that the trial judge was in error in the way he directed or the way he instructed the jury on the basis of CJI 13-1. He said that in referring to the jury, the model jury instructions, that you are to use explanation of the legal basis if it's in question. And the judge instructed that the government, had the lawful authority to detain or arrest. He never addressed whether or not they were lawfully there and whether Ms. Warren had the right to lawfully resist. And given that, excuse me, given that resisting an unlawful command is an element of the offense, and when it is an element of the offense, then it's a factual issue for the jury. I believe that the judge took that factual issue away from the jury by improperly instructing. And that's the basis or the gravamen of our issue on issue 2. And I believe I did, without spending a lot of time looking for this. So on page 10 of my brief, it does cite to the Quinn case, an opinion of this court in Quinn at 305 Michigan Appeals at 494, that where it becomes a question of fact for the jury of whether it is in fact a lawful command. Beyond that, I have nothing further.
Any questions?
No.
I have no questions, but thank you.
Thank you, Janice.
Yeah, thank you. That case is submitted. And we will call the last case on today's docket, number 13, docket number 373-381. Truman Harrison and Modesta Harrison Trust versus Alowski. And I believe nobody is endorsed on that case. Am I right about that, Dan? Okay, that case is submitted on the briefs and we are adjourned. Thank you.